Members of the jury, with your indulgence and patience, we're going to go probably about another 20 minutes or so, and then we're going to recess for the day, okay? All right. Madam?
Mr. Copeland, what blood set were you a part of?
Can you repeat that?
What blood set were you a part of?
What blood set what I was part of?
Yes, sir.
I wasn't part of no real blood set.
Okay. Did you ever claim to be a Billy Blood?
I said I was.
Okay. And were you?
No.
Did you tell Detective Gaither that you were, I mean, not Detective Gaither, Detective Lewis, in that February 21st interview that you were Billy Blood?
I don't know what I told them in when they questioned me.
Okay. Do you recall talking to Detective Lewis about the meeting with Mo where they said that they were going to kill you?
Huh?
Do you remember talking to Detective Lewis about the meeting with Mo, who was in prison, and that they were planning on killing you?
I don't recall.
Okay. And do you recall her asking you why you weren't at this meeting?
Huh?
Do you recall her asking you why you weren't at this meeting?
Why was I at the meeting?
Why were you not at the meeting?
At what meeting?
The meeting with the Bloods, the meeting of the Bloods trying to kill you.
I don't recall.
Okay. And do you... Sure. February 21st.
What year?
2015. And then, do you recall telling her you weren't down with them, but that you were Billy Blood?
I don't recall.
Okay. And then, do you recall her asking, who are you with now?
I don't recall.
Okay. And you told her, at that point, they got mad.
I told her.
You told Detective Lewis.
Oh, this a lady?
Yes. At that point, they got mad because I didn't go back with them. I started hanging out with Thug and them, so I'm YSL.
No, I don't recall.
Did you consider yourself part of the gang YSL?
Basis.
It's an improper question.
I didn't mean for you to speak. I just want you to give me a basis.
702, and being problems of the
Overrule, sir.
Did you consider yourself part of YSL, the gang?
Gang, I consider myself 372.
When did you consider yourself 372?
What you mean, when?
Did you consider yourself a 372 when you called yourself Billy Blood?
I always been 372.
So even as a part of YSL, were you considered, or do you consider yourself 372?
Gang, I'm always 372 when it comes to gang.
Did you also consider yourself part of YSL?
372 when you speaking on gang.
Yes or no? Did you consider yourself a part of YSL?
But you saying gang wise, like.
So you did not consider yourself part of YSL, the gang?
When it comes to gang, I consider myself 372.
Now, going back to June of 2015 when you were arrested for the Fed charges, we talked about the gun that was at the Dunbar Center. When you were arrested, where were you arrested at?
Which time?
When you got arrested in June?
June 10th?
Yes.
At the house.
Did they find any guns at the house?
Yeah, they did.
Were you charged in your federal charges with that gun? Do you recall?
Yes.
Okay. Now, once you were arrested, were you brought in to Atlanta Police Department headquarters for an interview?
Yes.
Okay. And do you remember how long? Okay. And during the course of that interview, did you speak with multiple detectives?
Yeah, I did.
Do you remember speaking with anyone from the ATF or
Yeah, I did.
and was Detective Gaither in that interview?
She was at some point.
What about Detective Dennis?
Who?
Detective Dennis, do you remember him?
Yeah, I think he was too.
Okay. And what about Detective Thorpe?
I think he was too.
Okay. And when you were arrested and brought down to APD, did you want to give them truthful information?
Again, I was going to jail.
Do you recall telling them that you're not going to worry about me lying?
Can you say that again?
Sure. In the early part of that interview, do you recall telling them you're not going to have to worry about me lying?
Probably so.
Why did you want to speak to the police that day?
Because I was trying to finesse my way out of jail.
And what did you think you had to do to finesse yourself out of jail?
Well, they're asking about Young Thug, so that's the direction I had to go.
Okay. Did they ask you about anything else?
They asked me about the gun. I think they asked me about the gun first.
Did they ask you about anything else?
Yeah, they asked me about a lot.
Do you recall them asking you about Nuts murder?
Yes.
And did you speak with them about Nuts murder?
Yes.
And did you speak with them about the gun at the Dunbar Center?
Yes.
And the gun at your house?
Yes.
Okay. And did you also speak with them about Young Thug?
Yes.
And did you talk with them about Little D from Mechanicsville?
Yes.
And what about Shannon?
Yes.
Now, when you got to that interview, did you believe that people were trying to kill you?
Uh-huh. I thought people trying to kill me for a long time.
Specifically in June, did you still believe that people thought you snitched on them regarding the murder of Donovan Thomas?
Can you say it one more time?
Sure. When you had this interview in June of 2015, did you think going into that interview that people thought that you had snitched on them regarding the murder of Donovan Thomas?
Overruled. No, I take that back. I'm gonna sustain the questions.
Why did you think people were trying to kill you?
Because I was paranoid. People were shooting at me.
Did you tell the detectives in this June 10th interview that everyone in the world is trying to kill me because they think I told on them?
No, I told them that people were trying to kill me because they said I killed Nut.
Do you recall telling the detectives about the fact that that Thug's sister had called you or had texted you?
Can you say that again?
Sure. Let me ask you this. Did Thug's sister ever text you regarding you going to the police about Nuts murder?
I texted her and told her that I was going to kill Thug when I get a chance. That's what you talking about?
No, but why did you text her that you were going to kill Thug when you get a chance?
Because I let a lot of people get in my ear.
And what did they get in your ear about? Its effect on the listener, Your Honor.
I'll say overruled objection.
What did they get in your ear about?
A whole lot of stuff. People were coming to me every 5 minutes with something about not just Thug. It was just a lot of people, but mainly most people was coming to me about Thug.
What
So-
about the,
Nah, they just kept coming to me like, he ain't right. He ain't supposed to. I don't know how to answer that.
I mean, but what were they telling you such that you thought that you had to kill Thug?
Say it again.
What were they telling you such that you thought in your mind you wanted to kill him?
That to watch him because everybody saying I killed Nut and they didn't want that on them, so they gonna put it on me. I don't know. Like it was so many different people just telling me stuff. So
But to kill somebody, what were they telling you to make you think you had to kill Thug?
what did they tell me that made me think I had to kill him?
Yes.
That I better watch him
Why?
because they said I was messing up his career. Like they saying that I was putting him in stuff that I got going on. Like they were saying all type of stuff. Like
So why would you messing up his career mean you have to kill Thug?
they said me, okay. A female came to me and told me that she heard something. Then another person came to me and told me that he heard something. So people kept coming to me and I was paranoid because I had said something to a friend of mine where I felt as in whatever I was saying to him had got back out.
So let's start there. What did you tell your friend? That guy that you think got back to him?
I was planning on him.
Why would you be plotting on Thug?
I don't recall.
Okay. Do you recall telling the detectives that you called, that Dolly texted you and was cursing you out?
Yeah.
Okay. And this is years ago. Do you remember what she was cursing you out about?
Because I told her I was going to kill Thug when I see him.
Okay. Do you recall the last 4 digits of the number that she was texting you from?
No.
Do you recall giving that full phone number to the detectives?
No.
Do you recall giving them a phone number ending in 1990 for his sister?
Probably so.
Which sister are we texted you?
Dolly.
Okay. Did she have another name?
I said Dolly.
Did you call her something else?
Yeah, I call her Dolly and Max.
Okay. Do you recall texting Dolly, damn, your brother's trying to have me killed?
I probably have.
Okay. Why would you text her that?
Because I thought what I was said to somebody else had got back to him.
So what did you tell somebody else that you thought got back to him?
I don't recall.
Okay. What, again, would make you text that to her brother, to Dolly? Damn, your brother's trying to have me killed. You know what I mean? Like, what the hell I ever did to him? Why would you text that to her?
I told you I was paranoid. It was so much going on. It was so much going on. I had so many people in my head. And that's just my way of trying to force a reaction.
Force a reaction from who?
From him, to see how he react to it.
Why were you trying to force a reaction from him?
Because I didn't know what the truth was. I didn't know. I didn't know. I didn't know what was going on.
Now, we talked about in February, strike that. We talked about in January, people thinking that you had killed Nut, right? Also in February, did people think you were trying to kill Nut?
Huh?
Did people think that you killed Nut, excuse me?
Objection calls for speculation.
I'll sustain the form of the question.
Did you believe that people thought that you killed Nut?
Did I believe it?
Yes.
People were convinced.
Okay. By the time we got to June, did you still have that same belief? When you
Did
got
I
arrested,
have that belief?
yes, when you got arrested in June, did you still have that same belief that people thought you had done, that you had killed Nut?
I don't know, like, so many, it was so many people was on so many people just like, a lot of people said they know I didn't do it, but a lot of people said I did it. So I don't
And I'll ask you again, did you kill Nut?
know.
Okay. Now, when you got to this interview, do you recall speaking with the detectives about the night that Nut was killed?
Can you say that again?
Sure. When you got to this June interview, do you recall speaking to the detectives about the night that Nut was killed?
Yeah.
Okay.
What interview?
The June one?
Yes.
Okay. Now, did you have concern during this June interview that Thug had observed you speaking to police?
Huh?
Did you have concern during this June interview that Thug has seen you speaking to police?
No.
Do you recall telling the detectives in this June interview, long story short, the detectives was calling my phone and he was right there. And they asked you, Thug was right there? And you said, yeah. So I answered the phone and he's looking at me like this, but I don't know what's going on. They asked you, why is he looking like that? And you said, because he see me answering the phone for them.
No, he told me that. When I answered the phone, I answered my phone on speaker, so it was my baby mama calling saying that the investigators wanted to talk to me. I was like, for what? And that's when he said what he wanted to talk to me about. And he got on the phone, asked me, could I come down there and interview him? And Thug like, go down there.
Why were you concerned then that he saw you answering the phone for the police in front of him?
I don't know. I don't know about him being concerned.
Why would you tell the police that?
Because it's the police.
If there wasn't an issue, why would there be a need to tell the police that Thug was?
Because at the time the police questioned me, it was me against everybody. So they saying that they want Thug, and that's what I'm trying to do. Get them up off of me. So I had text Thug phone the day before they locked me up. And I texted their phone and told them that I was gonna kill him when I see him. So the police got me the next day, and when they got me, that was it.
Let's go back. What day are you talking about? You texted
June.
in June. You said you texted Thug. Who did you text?
One day, I texted their phone. I called his sister and told her, tell your brother when I see him, I'm gonna kill him.
Okay.
I don't care who see me, I'm gonna. Me and her arguing on the phone. Today,
That conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right, so I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well. So we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround. So we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Do y'all think? Otherwise, give me something else we can do this morning.
Yes, we can do that. If you can, we just need to get that material very quickly to the office, to the courtroom.
All right. Send somebody to go do that, please. And has anybody thought through yet, and maybe we'll have ready soon, any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony, and then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I will get the exact language that I'm speaking of.
All right, great. Thank you. I appreciate that. Okay. Anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, and I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, and I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
Oh, the giant list of.
the giant list of
Okay,
exhibits.
yeah, that's fine. That can be next Wednesday.
Okay.
That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes, Your
for
Honor.
that. I
And I-
thought you meant Mr. Copeland's testimony.
No,
Okay,
Your
all
Honor.
right.
No.
My misunderstanding then. Okay. All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the.
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this, and we're okay with that ruling?
We believe
That's
out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
I just want to, we don't think there's many, at least from the state's perspective.
All right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before the
one.
Monday.
Sorry,
And
I'm
Yes.
sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful. Yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there, and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level a assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's, got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Sharp, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot. So
Well-
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. If y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money.
Brothers and sisters, good morning. Hope you're doing well. Weinstein is doing what he should do right now. And it was important. Sharp turned the page, turned that corner right there, and he let the passion flow. And Weinstein, we know we don't see him like this on a regular basis. So what we spoke about yesterday, right? We said, hey, somebody's going to have to slow this train down. Somebody's going to have to do something differently. And we talked about how this team was going to be calculating. They were not going to observe that they have a different judge and a different MO of how she's going to operate, and they're not going to adapt. They have way too much experience. They are too good at strategizing. They are proficient in their craft. So when they were looking at what was happening yesterday and they're watching what she's doing, hey, they're calculating. And you can see today there's a different tone. Why? Because, hey, we can't just let her just go through deny, brush off. So the fact that Weinstein even got back up, right? The fact that he even said, hey, you weren't there. And we know he's been very deferential. We know that he's been trying to, keep the peace with the new judge. They all have. But where's that getting them? Where's it getting them? So at some point, wait a minute, Judge, wait a minute. You weren't there. So you can't just brush it off and act like no big deal. I'm offended by that. So she's bringing this on herself because she wants to operate like a primetime scheduler, right? Keeping the trains running on time. And they're like, wait a minute, skip the trains running on time. What about what's going on? This is some deep stuff. And you're just trying to be surface and just get through it. You're just on to the next. This ain't McDonald's. Slow this thing down. So shout out to Weinstein and Sharp and whichever side you're on. If you're on the state side, defense side, you got to know. I mean, this is still educational. Why? Because cats are pushing for their team and they're adapting and they're rolling with these punches and finding a way to win. That's what you got to do. That's what you got to do. Thanks for being here. Rhodes, Dogs, and Conversation. Let us know what you think. We appreciate you being here. Let's roll.
I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right, well,
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being what the other side is saying.
See now that right there. Well, what do you think, brothers? Wouldn't you be offended by that? What she just told you? Now, they have been go along to get along. They've been chill with her. They haven't been giving her the true funk. And she's still going to say, even though they haven't been giving her the true funk, they've been choppy, not trying to say too much, sit back down. Yes, Your Honor, honorable court. They've been doing the whole thing. And we know these guys can talk. They got verbals. But we've been watching them be chill. And then she going to come behind that and say, well, you got to be careful. In other words, you guys make sure you're not just grandstanding. Grandstanding. Again, you trying to minimize the depth of what we're talking about so we can just move on. What the heck? So, to me, that was one of the most offensive things that she said. But she's proving that her goal is move on. Her goal is, hey, let's keep the schedule. No, what we are talking about is serious enough that we are arguing as defense. I'm saying as defense, we're arguing for mistrial. And you're acting like it's just, hey, would you like to come back for lunch in 10 minutes or 5 minutes? Would you like to come back from a break in, at 2:45 or 2:50? You see what I'm saying? Okay. Well, we heard everybody. Well, then don't be emotional. We heard everybody. Let's move on. She's dealing with a mistrial motion and reasons for mistrial the same way. Proportionally. And they're like, whoa, what is going on? And now you're going to caution us about grandstanding. Grandstanding. That insinuates that we don't have the true reason to feel we're feeling like we're acting now. Acting? Okay. I mean, we're under oath to passionately advocate for our client, right? Et cetera, paraphrase. I mean, we are under oath that we have to give a vigorous defense, best of our ability. Well, I tell you, I'm more and more, and yesterday we talked about it. If you didn't get a chance, check out the stream yesterday. But brothers and sisters, more and more, I'm not feeling Whitaker. Now, if this was an issue where it was all we needed was somebody to just move it along efficiently, I think, she certainly has that skill set. But you can't just move things if there are truly deep issues. And one of the reasons why we even study this case, this trial, is because of all the foolishness that's going on. There's some deep, deep issues, and there are people's lives that hang in the balance. But there are some legitimate, deep issues. This is a doggone RICO trial to begin with. Shucks, it's a RICO trial. Shucks, what the heck? So even if all of the nonsense wasn't a part of it, right? Even if the other nonsense wasn't a part of it, it's still a RICO trial. So it still ain't something you should just be skirting through. And then you compact that with all the other drama that's going on. You bring in a guy who's worth multi-millions, a world-renowned entertainer. You put him in the mix. You got the cameras in the mix. You got the length of time the jury's been going through this, and the brothers have been without bond. You got all these complexities. Now you recuse a judge. First of all, you go through all this nonsense to get the judge in the position to, for the proper recusal. All these things, all these shenanigans and more, right? And more. And whether or not the case should even have been brought, right? You still have people all throughout the world who are saying, was this even necessary? Was it even proper? Was something else going on with Fonnie and the rest of it? Is something else going on? Are there other reasons why this thing is even here? So you got all this going on, and she gonna talk about, gotta just move on. Let's keep it going now. She moved through the stuff so fast, brothers and sisters. Yesterday, she coming in here, even yesterday, hey, what else do we have to talk about? Is there something else we can talk about? Is there something else we can do? She flew through the stuff so fast in one day. She ran out of stuff yesterday. Go look at it. She started this morning the same way, like, hey, what can we do? So yeah, if you want to give a brownie point, or if you want somebody to run through stuff super fast, I do tip my hat to her. We're fair. If that's what you're looking for, Whitaker, if you're looking for somebody to say, hey, we got 5 cases and we need them all taken care of today, can you handle it? Yeah. And then what you want me to do? Whitaker's your person. And no disrespect, if that's what you were looking for in a judge, she can handle that. I mean, in the way I'm looking at it, she can handle it and go to the park afterwards. She can handle it and go dancing tonight. I mean, it ain't even bothering her. It's not even gonna faze her. She will cut through that case, cut through and have the trains running on time, and y'all will be out of there. She can do it. But when you're dealing with this much, the minutia, the details, when you're in the mud like this, for real, I'm looking for that brilliance we talked about yesterday, brothers and sisters. And I think the defendants deserve that. I think the case deserves that. Let us know what you think. We appreciate you being here. Smash that like button. Thank you for being here. We appreciate sharing this time with you. Shout out to Miss Mod. Let's go.
And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean, all right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the 2 transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing. You know,
Okay.
we're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe. I heard what you said yesterday. I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but.
I add one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So there's like two layers of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that. And it was a flat out lie. And I'm paraphrasing, but that is what they're talking about. Correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement, in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and the 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes.
Okay, brothers and sisters, we get to see the chemistry between Hilton and Whitaker. So we know that Love was in the first chair on yesterday. So Hilton, they've swapped seats, and now Hilton and Whitaker are having their, let's call it their first real interactions. So let's see what's going on with that.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead. We can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
Your Honor,
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
To my belief. If your court thinks that's good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Miss Love and or Miss Hilton perceived and therefore caused them to want to speak to the court ex parte don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court.
Brothers and sisters, this is a big one right here. So again, Whitaker saying, let's keep the trains running, let's just move on. Wow. Anyway, so Brother Steele says, well, Melnick, seems like we could bring him in right quick. Melnick, right? Remember, that's Woody's attorney who had the vacation, and that's how we got Bumpus to fill in, right? So he's saying, well, Melnick can come in because he can come in right now and give you some insight on these emails and these accusations that Love and them were making. Boom. They're not letting it go, brothers and sisters. They're finding ways to continue to get back to their points of saying this stuff needs to stop. Now, who would have thought that today Melnick was going to be showing up? I'm telling you, you have to strategize. You have to find ways to win, brothers and sisters. These cats are not just sitting there watching the trial. They're analyzing, they're strategizing, they're fighting for the win. Focus, focus, focus. Thank you for being here. Smash that like button. Let's go.
That were misrepresented by Lawyer Love. I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that it did not go to the holding or the ruling, and she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, "Oh, you seem to want to talk to him, so I will let y'all talk privately," which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by, we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interests, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight because Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with this honorable court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding, it's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them had been in January, but I cited them in the footnote of my motion to just educate the
Okay,
court.
well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases and what
Step back.
okay.
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton, Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I see, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand. And I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th? Okay. So let me make that determination.
I'd like to call him if you change your ruling. Both Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this happened. I want to get it right.
all right, so you haven't talked to him yet about what? All right, well, obviously I'll give you a chance to talk to him before you make a proffer, because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Okay. Thank you.
All right. So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay. All right, let's come back at 11.
Boy, this is some weird stuff.
Of other work to do too. Okay.
Looks like she made one more statement before. All right, brothers and sisters, I mean, this is some weird stuff. What do you think about this? I'm telling you, man, this, boy. Again, if you like this kind of thing, just speed. If that's your bag, she's got it for you. Speedy Whitaker, as we're now calling her. She's got that for you. Don't need to do this, no need to do that. Well, what do you need to do that for? Yeah, well, I mean, hey, if that's your bag. But if one of these cats were your son, and you're knowing that there's a chance here for mistrial, if you can argue these points effectively and efficiently and deeply, you're saying, whoa, or even just the bond hearing request yesterday, the motions, right? I mean, if that's your son and you said, well, wow, it just seems reasonable. It's been years now. It just seems reasonable that bond, is possible. That just really seems reasonable. If that was your take, She's not going for it. Quickly, Speedy Whitaker, nah. Next, no. Next, no. Next. But as you see, run out of stuff to do. Now you gotta know there's something wrong. You gotta know, with the level of expertise of the defense attorneys in all those motions, and she went through them so fast, she has nothing to do. You have not heard, not one time have you heard, okay, well, I'm going to go back and do some work while y'all be out here doing some work, because we ain't even got nothing to even talk about right now. That's comedy. That's a comedy show. Meanwhile, no. We don't even need to do that. No. Okay. Now, she's going to go back and she's going to review some things, and per what she said, she's going to come back and, deny that those are the odds, right? Deny some of the things that she held on yesterday, that she reserved opinion on yesterday. So she was basically, no, okay, I'll get back to you. No, I'll get back to you. So essentially, what we're looking at when she comes back, if this is what she wants to do, just go ahead and put it on the record, her ruling on a few more things. The way she's talking, it doesn't sound like she's inclined at all to bend or budge on the mistrial, etc. So we'll see. She's gonna give about an hour or so. So what we'll do, brothers and sisters, we'll go back and revisit some Lil Woody. In the meanwhile, thank you for being here, Rhodes, Dogs, and Conversation. Hang tight. We'll bring up a little Lil Woody. How about that? All right. Let us know what you think. What do you think about Whitaker? Is this your style of judge? Does this work for you? A master scheduler? Or do you want someone to really, really be deep into the arguments and the process of which to make sure that everything has been firmly understood? And let me just say that too, brothers and sisters. It would also be different if Glanville was doing what she's doing right now. Now, hear me on this, brothers and sisters. Check this out. Because at least he had been there, right? So at least if he started moving really fast, then you wouldn't be saying he's skipping over stuff, because he was actually there for all those days, weeks, months. He's actually been a part for hour after hour after hour of all the testimony. He's been looking at these people, living with these people, quote unquote, for all this time. You feel me? So that's why it's even more offensive that she comes in with this speed attitude, because she wasn't even there. And you know that within your own life. If you've been going to your church for 30 years, and somebody comes in new, okay? I mean, we thank God for you. You have every right, privilege, responsibility as any other member. Okay. So you come in and you bring your talent, but you ain't even been here but 5 seconds, and you already just turning down stuff and rearranging stuff, and and we trying to tell you about things, and you're not even letting us tell you about things. We know you don't know, but you acting like you know, but you can't know. For you to know everything we know insults us. How are you going to know everything we know when we've lived this thing? So, okay, we know you don't know, so we're trying to tell you. It's not like we're not trying to tell you. We're like, okay, we'll share these things with you. There's some things you need to know. Nah, I got it. I read it. I'm good. Let's go. You read it. Hold on. Wait. You read what I wrote. I wrote the motion. So how are you going to be on my level when I wrote the motion? There's things I didn't put in the motion that helps you to understand. There's things that I put in there that you might not even understand, even if you did read it, because you still weren't here. I didn't know you were going to be reading this motion the way you're reading it. You know, there's a style to the motion, right? There's a style. If you understand what I'm saying. In other words, if you know that you're trying to convince, let's say I'm going to try to convince Barack Obama of something, and I'm going to write a motion to Barack Obama. Well, you're going to write it in a certain way. Now, what if you're trying to convince Brother Trump of something? Are you going to write the motion the exact same way to Brother Trump that you would to Brother Barack? Are you going to write it in the same way? They're two different people. So if you know who's going to be reading it, you might craft it a little differently. Either way, now I have to be a master motion writer because you're not even going to hear my full argument. You just want to know if there's any gaps, anything else. Okay, well then I got what you wrote, so I'm good. Again, you haven't been here, so you need the benefit of everything at this point. You need what I've written. You need my full argument, unmitigated argument. You need all that because you're looking for you're trying to catch up for real, not just run through. You're trying to really get depth here. I mean, it's almost like you want to listen. You want to listen because there's other things you're going to catch as a cheat. There's other things you're going to catch just by being around us, just by hearing more and more. It's like, okay, I heard this, but I'm going to listen because I'm trying to pack in months and months and months in a couple hours, which is, how is that even possible? But this is what I'm trying to do. So I'm not stopping you from talking because I know it. I'm cheating. I'm going to keep listening. Like, yeah, I know what he's talking about, but he might say one or two things that I can get about this trial, or I can get about the people in this room, or I can understand, or, you know, so my best bet is to be quiet right now because they giving up the jewels. They giving up the intel. Let me sit here and listen because I acknowledge I ain't been here. And there's a whole lot of stuff going on in here. And I might be able to pick up on it if I shut up and listen. Nah. I'm just going to move through it. I read it. I'm good. Let's go. All right, Speedy Whitaker. I'm not so much a fan unless you just want the trains to run on time. Thank you for being here, brothers and sisters. Smash the like button. Rhodes, dogs, and conversation. All right. So anyways, in the meanwhile, what we're going to do is jump on a little bit of Lil Woody in the meanwhile. Let us hear from you.
The detective left the room and you were speaking with your girlfriend and you told her that you knew who shot at you.
I never saw nobody. I never saw who shot at me. If I saw who shot at me, I would never told the police who shot at me.
Do you recall in this same February 20th, 2021 interview that when the detective left the room, you said to your girlfriend, this shit not gonna work. Sit right here and be a damn snitch, so I'm gonna keep going. Do you recall telling your girlfriend that?
I don't recall.
Okay. And then she responded, so, you're right, it'll be effect on the listener.
Overrule the objection, sir. Overrule, sir.
So what you're saying is why you acting like you did? And she said, you should have just said, no, I thought you know all of them. And you said to her, I do know who it was. Do you recall telling her that?
I know that I knew the camera. I knew that I was being recorded. So I kind of knew what I was doing.
Okay. And then you said, I saw him. I did when he jumped out the car. I know exactly who I saw.
Nobody never got out of the car. So this clearly proved that I knew what I was doing.
Do you recall telling your girlfriend that?
I don't recall what I told her.
Okay. And this was when the detectives had left the room.
I don't recall if they left the room or if they stayed in.
Do you recall further in the interview when the detectives asked you whether or not any of the people who did this had ever been to your home, you instructed your girlfriend to tell the detectives who had recently been at the house?
I don't recall what I told them.
Do you recall the detective asking anybody you let come over to the house recently that normally ain't been by there? And then you told Deshaun, tell him who been there. Do you recall that?
If I brought anybody to my house, I'm 100% sure they know not to play with me.
Okay. Do you also remember when you and your girlfriend were in the room by yourself, you told your girlfriend it was Tay and them who did this to you?
I don't recall.
Was it Tay that shot at your vehicle?
I don't believe so.
Do you recall in that same interview being concerned about being labeled a snitch?
I don't care about what I'm being labeled as.
Let me ask you this. During this time when your home was when you were being shot at with your daughter and your then girlfriend, how many other family members' homes have been shot at that year?
Objection calls for speculation.
I'll sustain as to speculation. I will overrule as to hearsay from Mr. Steele.
To your knowledge, how many of your family members' homes have been shot up back in 2015 after Nut died?
Objection relevance.
Overrule, sir.
I can't recall.
Do you know? Okay, let me ask you this. Was your brother's home shot at?
No.
Okay. Was your girlfriend's mother's home shot at?
Yes.
Okay. Was your sister's home shot at?
Yes.
Was your grandmother's home shot at?
No.
Did you think you were being retaliated against?
Huh?
When all the shootings were happening at your family members' homes, did you think you were being retaliated against?
I didn't think.
Did you know?
Clearly.
Okay. Why were you being retaliated against?
Because people said I killed Nut.
And do you know who was doing the retaliation?
No.
Do you recall telling detective in the same February 20th interview that it was a whole gang after you?
Anytime the investigator talked to me, I do not recall what I have told them.
So you don't recall telling them there was a whole gang after you?
I would told them whatever I think that I need to tell them to convince them to stop watching me.
Was there a whole gang after you?
I don't know.
Was the entire IF gang after you?
I seen a few of them, so I can't say that.
Which were the ones that you saw?
I don't know.
Earlier, I asked you about whether you were concerned about being labeled a snitch. Do you recall telling Detective Copeland?
Detective who?
Excuse me, Detective Copeland. Detective Curry.
Now I'm a detective.
Or was it? I made a mistake. I'm talking about
Correct.
Detective Mr. Copeland. I'm about to ask you a question. Do you recall telling the detective, I know if I tell you what's going on, they're going to be on records and all this here, and you're going to get him locked up, and he's going to get his discovery package. First thing they're going to do is send it to two places, to the street and to prison, and float it all around the city of Atlanta and then all around prison. But my name's over that. I'm not going that way. No, I'm not going through none of that. Look, they shot at me, my girl, and my baby. Almost shot my face off as we were running. I'm not for sure, but I thought one of the bullets hit the car seat or grazed the car seat. Were you concerned about snitching in this interview?
I was concerned trying to get my story together, so I was trying to buy time.
Did you also tell in that same interview, I just know the trouble I'm putting myself in. Just know I don't want to have nothing. I don't want to have nothing, man. I can't go to no job. I can't do none of this shit. I know the street not going to be here forever. All things going on right now, just waiting on you niggas to catch up and kill me. Again, not wanting to snitch on who did this to you, your child, and your baby.
My only motive was, anytime the police questioned me, was try to figure out how could I get myself out of it. Anytime they asked me any questions, I was trying to, if I couldn't come up with no answer right then and there, I was trying to buy time to think of something to say.
When you met with Mr. Curry, weren't you going there as a victim of an aggravated assault? When you went to go meet with the detective that's in that picture,
Okay.
weren't you going to talk with him about being a victim of a crime?
No, I was shooting back. So I thought they were going to try to lock me up for shooting back.
But during the course of that interview, were you made aware that they weren't planning on arresting you because you were protecting yourself?
When they said they would take me downtown, I put my hand behind my back and told him, "You gonna lock me up? Come on, get it out the way now."
And did they ever lock you up?
Cause he wanted the gun. So he gave me 24 hours to give him the gun. When he let me go, I didn't come back with the gun. So they sent the SWAT team to my house to get me.
But when you went the first day, did they ever put handcuffs on you?
Cause they wanted the gun.
Did they ever put handcuffs on you?
You hadn't answered the question. Overruled.
Did they ever put handcuffs on you?
One of the officers pulled him out and he told him we don't need that.
Okay, so they never put handcuffs on you?
Overruled, sir.
Did they ever put handcuffs on you?
I don't think so.
Okay. And when you left the interview, did you leave that interview without any handcuffs on you?
Yeah, I left. I went back to the streets.
So again, when you went in this interview, you were not in trouble.
I was.
Basis. Overruled, sir.
Were you arrested at all on February 20th when you went to go speak to the police about being shot at? Were you ever arrested that day when you went down and told the police about what happened to you, your child, and your girlfriend?
They locked me up the next day.
I asked you, were you arrested that day?
No, they locked me up the next day.
Were you arrested that day?
Objection, Your Honor, arguing that it's been asked and answered.
Overruled, sir.
Were you arrested that day?
No.
Did you want the police to go and find the people who actually killed Nut so that people would stop retaliating against you?
Yeah.
Do you recall being asked by the detective, you knew one of them. I know you knew one of them. Your face tells the story. Now, out of all the ones, I mean, you might know the other ones, but I know you know one of them because the face tells the story. Because the face tells the story of somebody being close that you trusted. And your response was, it ain't that. The truth is, I wouldn't say that person because I'm not 100% sure, but I know only one person.
What's the base of your objection, sir?
Foundation, predicate.
Okay. All right. Foundation and predicate. I'll sustain the objection. Go ahead and rephrase, madam.
Did you know at least one of the individuals that were shooting at you back in February of 2015?
On my daughter's life, when that car pulled up on me, all I saw was a gun come out the window. They said, I never seen no one face. They was questioning me. They constantly kept telling me, you gonna let dudes shoot at you and your kids and this and that. And I'm telling them, and they won't believe me that I'm telling them, I didn't see nobody's face. I didn't see nobody's face. And then after a while, I got tired of them asking me, so I don't recall if I just went ahead and said, yeah, I seen Tay. I don't know how it came out, but in my heart, and still to this day in my heart, I do not believe Tay had anything to do with me getting shot at.
Okay. Do you recall telling your girlfriend when it was just the two of you, I did when he jumped out the car? I know exactly who I saw.
I don't, at that point, it was so much pressure on me. Yeah, I'm a daughter crying, I'm trying to take her to the hospital. Somebody pull up on me, shooting. I'm trying to figure out what made me have the gun to go to the hospital. It's all type of stuff going through my mind. I don't know. Too much going on. Yeah, I can't because she keep asking me these questions and.
Mr. Copeland, just take a breath, okay? We do need to take down your testimony, so you do need to speak a little slower, all right? Okay?
All right.
Are you? Can we continue?
I don't got anything else to say.
About which part? Regarding the gun that you used to shoot back at these individuals, who were you going to give? Which police officer were you going to give the gun to?
Huh?
Which police officer were you going to give the gun to?
Neither.
Okay. Who did you tell them you were going to give the gun to?
Whichever one they were asking for it.
Do you recall them telling you needed to give the gun to Gaither?
I don't recall. I know they said they want that gun. It's part of the investigation. I knew it was a trick. I told him if he let me go, I go get it and bring it back. He went for it.
And why didn't you get the gun?
Huh?
Why didn't you go and give them the gun?
You know, it helped him lock me up.
At any point in time, did you ever get arrested for shooting back at those individuals?
Thank God.
Do you recall them asking you some more questions about Tay, and you providing them information about where Tay was from, what part of Atlanta he was from?
I don't recall.
Okay. Do you recall the detective asking you, we only know there's a guy by the name of Tay. Where's Tay from? What area he live in? And you told him that he was from Simpson Road area. You recall telling the detective that?
I guess I don't remember what I said to him.
Do you recall?
Because at that point he had put too much pressure on me, and you know what I mean. I'm just thinking because he told me. I remember him saying he want that gun. That's all I remember him kept saying. He want that gun.
And when you say putting pressure, what do you mean?
Same thing you doing to me now. You keep putting pressure on me.
Okay. Was he yelling at you at all during this interview?
I think he kept saying, I'm letting people shoot at me while I got my child, and my loyalty to the streets, my loyalty to my child.
Okay. So was he just trying to get you to tell him who did this to you, your child and your baby?
I stand the question as a form.
Did he ever threaten you to give a name?
Nah, but he kept asking me to make me say a name, and like how you keep asking me a question, I'm gonna say something to answer you, so you can stop asking me the same question.
Were you concerned about how you were going to survive the attacks on you and your family?
Yes.
And again, were you concerned that because you had already spoken to the police about Nuts' homicide, that people were considering you a snitch, that people thought you were a snitch?
I don't get what you're saying. Can you say that again?
Were you concerned that people already thought that you were a snitch when you did this interview
What interview?
with the detective after you were shot at? After you were shot at with your girlfriend and your daughter?
No, my only concern was, no.
Do you recall telling the detective in this same February 20th interview, I came and talked down here. Everybody look at me like I'm a snitch now. It's just like I can't get no money. You know, I was just getting money just by doing nothing. It's just like, hey man, I need to borrow this right here, just hanging around, going to the mall. He paid for everything, but all of them now, they all come out here, they think I'm a snitch.
I always got my own money. When I need money, I knew how to go get it.
Would Thug give you money at times?
I'm not a handout type of person.
Would Thug give you money at times?
I never asked Thug for no money.
Would Thug give you money at times?
I can't recall if he gave me money, but I never asked him for no money.
When you said he paid for everything, who were you referencing?
The big money, the ballers.
Okay. Were you concerned that Young Thug had washed his hands of you?
Huh?
Were you concerned because you have been speaking to police that Thug had washed his hands of you?
No, I didn't need Thug.
All right. Do you recall telling the detective in the same interview on February 20th, 2015, he asked you, so basically Young Thug washed his hands of you? And your response, yeah, because I came and talked to the detectives and the folks in the street saying I'm a snitch, I'm a snitch, I'm a snitch. Nobody don't want to hang around me. I called my partners. They don't want to hang around me. It's like, what the hell? What the hell all this come from? What the hell is going on? Do you recall telling the police that?
The police so concerned about Thug, I was removing myself from him.
Do you recall at all talking to this detective about what happened that Monday night at Club Crucial with you and Kel, the fight between you and Kel?
I don't recall nothing specific that me and him talk about outside of the shooting with my child. And I barely remember some of this stuff. You talking about some years ago when I don't even know what I did 3-4 days ago. Like,
Do you recall telling your girlfriend, again, when the two of you were alone in the room, no matter which way it go, I'm going to lose anyway if I tell them that Tay did it? You recall having that conversation with your girlfriend?
Did you say it again?
Sure. Do you recall being alone in that same interview room with your girlfriend and you told her, no matter which way it go, I'm going to lose anyway if I tell them that Tay did it?
On my child life, once again, on Izari life, I never seen no one face that was in that car shoot at me. At any time, if they got the car, to this point, I never knew who shot at me. So when that detective was asking me, I just had to come up with something. I got no reason to lie about it. I didn't see nobody who shot at me. So y'all going back into interrogation when I'm telling you the truth. I don't know who shot at me. I have told them I didn't know. When they're going to keep asking me, make me know, okay, cool. I'm going to say, I'm done.
Do you recall being hesitant in the February 21st interview, and we're going to get to that interview with Detective Gaither, when she showed you a photographic lineup and you actually eventually pointed Tay out of a photographic lineup?
Because I know Gate. I mean, I know Gaten. I know that, you know what I mean? She one of the people that she got it out for me, so I didn't care. I was just trying to get them out for me and trying to convince her. And trying to convince her is very hard to do. So I had to go through with it. Even though in my heart, I knew that he didn't shoot at me, or he wouldn't have never shot at me. And to be more clear on it, before I went back to jail the last time, I was right around him. So I would never be with nobody that I believe shot at me while I had my child.
Why did you say Tay did it versus anyone else?
First thing came to my mind.
Why was Tay the first person that came to your mind versus anyone else?
Because in the midst of trying to convince the police so they could leave me alone, I just got shot at. Only thing that was in my mind was, get back.
Okay, but you had to beef with Kel. Why not say it was Kel?
Because I had to convince them. I gotta make it seem. If I say Kel shot me, they gonna, how you know? How Kel know where you stay at? So I gotta come up with something to make them know. Okay, well, Tay been over here. You know what I mean? So Tay. I don't know. But listen, you keep asking me. I told you I don't know who shot at me.
Why would Gaither have it out for you?
That would be speculation, sir.
I sustain the objection.
Well, you said she had it out for you. What makes you think she had it out for you?
I'll let him answer that question. It's posed.
You said she had it out for you. What makes you think she had it out for you?
Because she was trying her best to get me. She was trying to catch me.
Didn't she advise you to leave town? But you're right, it's a contradiction of what?
Not a contradiction.
Hold on. That come from the interview. Where's that come from? Where's that statement come from?
His interview with her during the course
You
of
need to reference that. I'll rule the objection.
In your February 21st interview with her, did she ask you to leave town, go somewhere else, Cobb County, Clayton County? Did she tell you to lay low so that you wouldn't get killed?
No, she was saying it because she's saying that my name was she just said my name kept coming up a lot.
Right, so she did not want you to be harmed. So why would she have it out for you?
I sustain the objection. You can rephrase.
During the course of that interview, was she encouraging you to lay low? Do you recall her doing that?
I thought she was faking. So I don't know.
Outside of the interviews, would you talk to Gaither? Would you call Gaither on the phone?
No. The only time I talked to Gaither is when she called, but it was never about nothing in the streets or nothing.
Right, so
it was, hey, Miss Copeland, your name involved in the shooting. We want you downtown. This only time she called me, hey, Miss Copeland, they say you shot up this person's house. We need you downtown. I don't recall me and her having no conversations about nothing.
When you were locked up, would you have your girlfriend call Detective Gaither for you so you can speak with her?
You heard where I was, right? Where was I? In jail?
So if she had it out for you, why are you trying to call Detective Gaither?
Because I'm trying to, all she got to do is give me a name up here to try to convince her so she can get me out of jail.
But if she has it out for you, why would you trust Detective Gaither?
I don't trust her. I'm trying to play on her.
I want to go back very briefly to the interview that you did, the first interview you did with Detective Gaither, after your car was shot at on the highway. Okay. During that interview, at the time when your car got shot at, did you know about Lucci's mother's home being shot at?
What you mean?
Were you aware that Lucci's mother's home was shot at?
Huh?
When you met with Detective Gaither,
right,
about what happened on the highway, during that time period, were you aware of Lucci's mother's home being shot at?
No.
Do you recall talking to Detective Gaither in that January 28th interview about Lucci's home being shot at?
I can't recall.
During that interview, do you remember telling Detective Gaither and Detective Dennis that Lucci's mama and dad got shot, so Nick called Big Boo's phone, and we was at Big Boo's house? Do you recall telling them that?
I don't recall.
Let me ask you this. Do you recall independently being with Big Boo and Lucci's manager calling his house, calling his phone, trying to give him $20,000 to find out whoever shot up Lucci mama's house?
Form the question.
I'll sustain this form. You can rephrase.
Do you recall being at Big Boo's house and someone from Lucci's manager calling Big Boo back in 2015?
I don't recall.
Your Honor, can we vote?
Sure.
I can go out.
All right. Hold on. All right, let's bring Mr. Copeland back in, please. All right, so you can continue when ready.
Thank you. So I'll just ask you again. Back in 2015, do you recall being with Big Boo when Lucci's manager called him?
I don't recall.
Do you recall telling Detective Dennis and Gaither in the January 28th interview, Lucci's mama and dad got shot, so Nick called Big Boo's phone. We was at Big Boo's house. And the first thing that nigga said was, hey, Boo, Lucci's mom and dad got shot. Somebody shot up his mama and dad. Somebody's house got shot up. It's $20,000. It's $20,000, man. There's $20,000 on their head, or whatever they said. And you heard that conversation.
I don't recall.
Okay. And once you heard the conversation, that you took the phone from Big Boo and you told the person on the phone, I ain't did nothing. I didn't do that, bro. You know, don't scream my name. I didn't do that. And you kept telling that person that you did not shoot up his mother's house. Do you recall doing that?
I don't recall.
And did you shoot up Lucci's mama's house? You shake your head just so.
No.
Okay. Now, back in 2015, who were the people that you would spend the most time outside of your family? Who were the people that you would spend the most time with?
Huh?
Back in 2015, outside of your family, who were your friends that you spent the most time with?
My friends.
Who?
You want me to name every single person?
Yeah.
I'm not about to name every single person.
Okay. So who are the people that you would spend the most time with?
I can't recall.
Do you recall telling Detective Gaither that you only keep a couple people around you, and it's really just Little D and Shannon? Do you recall telling them that?
Probably so. I can't recall.
Okay. And then you also said sometimes Moonsoon, but he might come around, but not every day.
I don't recall.
And then you said, I really have my, then you also further went to say, I really wouldn't want nobody around me but Little D.
Your Honor, form of the question is my same objection.
I'll sustain the question. You can rephrase.
Sure. Between Shannon and Little D, who's the person you would have most around you?
Huh?
Between Shannon and Little D, who would you spend more time with?
I can't. I don't know.
Do you recall telling Detective Dennis and Gaither that I wouldn't want nobody around Little D?
I probably said it because I was trying to run the play on them.
Okay.
But I don't remember what I said to them.
Back in 2015.
Anytime they question me, like I said, you keep asking me about what I supposed to told them. Anytime they question me, I just said whatever came to my mind or whatever I could have thought of in a split second. So I don't know. I don't know what I said to them.
Back in 2015, did you trust Little D?
Say that again?
Back in 2015, did you trust Little D?
No.
Do you recall telling Detective Gaither and Dennis, I really have my trust in him, speaking about Little D?
You said I really had my trust in him?
Yes.
No, man.
And that,
Go ahead.
and that Little D ain't never going to turn his back on me.
I told you, I'm trying to tell them whatever they would have went for. Because yeah.
The gun that Little D from Cleveland bought from you from the pawn shop, what kind of gun was that?
I can't recall.
Do you recall it being, as you described, a chopper?
Probably so.
Can you tell the jury what you would describe as a chopper? What type of gun is a chopper?
I can't recall.
You don't know what type of gun a chopper is? Do you not know what type of gun a chopper is?
I don't know what I done told them.
I'm asking you separately. What kind of gun did Little D purchase for you?
A rifle,
Okay. Is a rifle a chopper?
I guess.
Okay. Have you ever had the occasion to give Nut back items that was stolen from him back in 2015 before he passed away?
Yeah,
Okay. First, who stole the items?
I didn't.
Do you recall telling me the other day that you did take the items?
Yeah, I said I don't.
Did you tell me
You
that?
just asked me, did I give it back to him? I gave it back to him.
Okay. My question is, do you know who stole it?
Huh?
Do you know who stole
I told him a friend of mine stole it.
it? Okay. Did you tell me something differently?
I probably did.
Do you remember what you told me?
What did I tell you?
Do you recall what you told me?
I just asked you.
So do you not recall what you told me?
I told you I gave it back to him.
Do you recall telling me that you actually stole those items, but you did give it back to him?
Do you have an objection?
Sir,
Basis.
prosecutor is the lawyer becoming the witness.
Yeah.
Are you talking about the foundation for the question or form of the question or what?
Is that the prosecutor testifying as personal knowledge?
Your Honor, I'm asking.
Cross-examination.
Your Honor, I'm asking a question, but I can clarify who all was in the room.
Yeah, why don't we do that? I'll sustain the question as to the current.
Do you recall meeting with me, investigator Long, and maybe investigator Lancico, and telling us in the room that it was you who stole it, but you did give the items back to him?
I can't recall.
When you gave the items back to him, do you remember where you were? Where did you meet him at?
In my neighborhood.
Okay. And was he with anyone when you met with him to give the items back?
I think so.
Do you remember who he was with?
I can't say who the people were there with him.
Do you remember him being with Greedy, his brother?
Probably so. I don't know.
Do you remember just telling the detectives in that January interview he was with Greedy, his brother was there?
I guess I don't know. I can't recall.
Do you remember what type of car Donovan had? Oh, excuse me, Nut had.
A truck.
Do you remember what kind of truck?
It was just a truck.
Do you remember telling the detectives back in that January interview it was a green Tahoe?
Probably did. I don't know.
Do you remember what the items were that you gave back to him?
Yeah, his driver license, phone, and his necklace.
Describe for the jury, if you remember, what the necklace looked like.
What you mean?
Do you remember what the necklace looked like? Do you remember what the chain looked like?
Yeah, it was a necklace.
Was it a peanut? Do you remember?
Oh, I think so. Oh yeah, I think it was a nut. I don't.
If you don't remember, it's okay.
Yeah, I don't know.
All right. We just talked about who you would hang around with from Mechanicsville. Do you recall telling Detective Gaither and Dennis back in 2015 that you're not going to see you hang with anybody besides Shannon and Dee, who is from Mechanicsville?
Shannon ain't from Canterville.
Do you remember?
I don't remember saying it.
Okay. And do you remember also telling the detectives that there's not going to be one time that you and D are not together?
I don't recall. But it's not going to be no time that me, D, and Shannon is not together. Not just me and D.
So the three of you will be together?
When me and D together, it's me, D, and Shannon.
Okay. Now, we've talked about briefly another interview that you did with Detective Gaither after you were arrested for probation once you, your child, and your child's mother was shot at. Do you remember that? All right. And do you remember meeting with Detective Gaither and you had gotten arrested?
No.
When you met with Detective Gaither once you were arrested, as you discussed, were you upset that they arrested you for failure to comply with community service? I know you're shaking your head. You have to say yes or no for the record. Right. And during the course of that interview, where you asked to tell Detective Gaither about what happened with you, Deshaun, and your daughter?
I don't recall.
Do you recall in that interview also talking to her about Nuts murder?
I can't recall.
And during this interview, do you recall telling her that on the day that Nut was killed, you initially were at home at Deshaun's house?
That's where I was, but I don't recall what I told her.
And that she got a phone call from Little D?
I don't know.
I'll sustain the objection.
We've already talked about where you were on the day that Nut passed away. Do you recall us talking about that over the course of the last few days?
I don't know.
Do you remember us talking about Nut's murder yesterday?
What you mean?
Do you remember me questioning you about where you were when Nut passed away yesterday?
You said you asked me that yesterday?
Yes, sir.
I guess.
Okay. If you don't remember, that's fine. Do you remember or no?
No, you didn't ask me yesterday.
Okay. Do you remember us talking about it since you've been on the stand, though?
Talking about what?
the day that Nut passed away?
Yeah, that's what it's about, right?
Okay. Cool. Your Honor, permission to approach?
As long as you're showing that to the defense counsel, please.
I'm showing you what's been marked as Exhibit 378, Yankee D1. Do you see yourself in that picture? Is that you?
I guess.
Does it look like you?
I guess.
Yes or no? Is that you?
If you say it's me, it's me.
I'm asking you, is it you?
Yeah, I guess. Yes, it's me.
And is that the type of giggler?
It's like a man.
Do you recognize that to be Detective Giggler?
No, I can't tell if I can't tell for real.
Was this? Your Honor, permission to. You have permission to approach?
As long as you show that to the defense counsel.
Mr. Copeland, I'm showing you a portion of 378 Yankee Delta on here. Does that look, do you see yourself in this video? Yes or no?
Yeah.
All right. Looking at this screen, are you able to tell who that is?
Yeah, that's her.
That's her?
Yeah.
Does that appear to be the same individual in the picture that I have in front of you?
It looked like the same picture.
Your Honor, this time the state would like to attend the state's exhibit 378 Yankee Delta 1.
Any objection to states 378 Yankee Delta 1? Hearing none, it's admitted and may be published as you see fit.
Thank you. Mr. Kearns, can you enable share? And if you could bring it down, Fred. No, down. And just fall out. Thanks. Look. Mr. Copeland, are you able to see the dates and the time of that interview?
Yeah, right there.
What is the date and time of that interview?
February 21,
Okay, and what year is that?
2015.
Now, during this interview, do you remember anyone else being in the interview room with you? Do you recall Detective Thorpe was in there with you?
I don't know.
Okay. And during that interview, do you recall talking to Detective Gaither again about what happened between you, Deshaun, and your baby?
I don't know. I don't remember.
Okay. And during that interview, did Detective Gaither also ask you who shot at you? Do you remember Detective Gaither asking you about that?
I don't remember.
Do you remember being concerned in that interview about being labeled a snitch as well?
I don't remember.
Do you recall Detective Gaither trying to encourage you to tell them who did it so she can help you so you don't have to be getting shot at in the streets?
But if I already told them Tay did, why would she be asking me that?
Because you recall this being the first interview with Gaither. You had not met Gaither prior to this interview.
I don't remember what me and Gaither talked about.
Okay.
Or what I said to her.
Do you remember telling her, if I tell you anything, guess what happens? That make it even worse. What makes it worse? Everybody, oh, now I'm a snitch. And remember her asking how you would snitch when somebody was trying to kill you and your baby. How was that snitching?
Okay. If there was the truth, why would I wait till later or at any point and say anything to the police? It's self-explanatory.
What is self-explanatory?
The whole thing. You seen here tonight what I told to the investigator, and I'm so concerned about being labeled a snitch. So why would I tell them the truth to anything if they trying to say I'm concerned about being labeled a snitch? So if I'm gonna tell them something that sooner or later gonna get out in the streets, why would I be concerned about being labeled a snitch? It doesn't make sense.
Do you recall being reluctant to tell the detectives who it was?
No, I was trying to buy time to come up with something to tell them so they can get up off me or let me out of jail.
Okay. The interview that you had on February 20th, what time was your interview on February 20th, 2015? What time did that
This paper?
Yeah, what time does that say?
What about?
What time is it on here?
1:41
What, AM or PM?
a.m.
And then what time did you meet with Detective Gaither?
Well, look like I got on a right street outfit, so I didn't meet with her. And it say 3:53.
On February 21st?
Yeah,
Is that PM?
p.m.
So did you meet with Detective Gaither the next day after you met with the first investigator?
Yeah,
All right.
that's what they say.
So if you just wanted to make something up, didn't you have time to make up a new name if it wasn't Tay?
See, with Gaten, it's harder to convince her. I got to, whatever I tell her, I got to stick with it.
Wouldn't you want to tell Gaither the truth if you were trying to get out of jail? If you were trying to get out of jail, wouldn't you tell her the truth?
But if she asks me about something that I don't know and I'm trying to get out of jail, I gotta act like I know.
Did you ever try just telling the truth to get out of jail?
Have I? Probably. I don't know what I don't told her, so I can't remember what I told her, so I don't.
How bad did you want to get out of jail?
I want to get out of jail.
So wouldn't you want to tell the truth to get out of jail versus lying?
Objection has been answered.
I'll rule the objection.
Wouldn't you want to tell the truth to get out of jail?
But if they ask me who shot at me, and I didn't see nobody shoot at me, and they constantly thinking that I seen somebody shoot at me, and I keep telling them I didn't see nobody shoot at me, they don't want to believe me, so what I got to do then? And if I feel like this is the only reason I'm going to jail, I got to stick to what I don't tell her.
So why tell your girlfriend that when no police are in the room?
I don't know.
Why tell your girlfriend that?
I don't know. I don't recall me sitting there just telling her that. I don't even understand how his name even came about from the start. I just know once I heard Tay, that's why I just stuck with Tay. I don't know if I brought it up. Which I doubt I brought it up because I didn't have no reason to bring your name up.
How would the police know who Tay was?
I don't know.
How would the police know Tay was even in your neighborhood at the time?
I don't know.
So why would the police bring up Tay?
Then I said, I don't know.
I sustain the objection.
Do you recall providing Detective Gaither a picture of Tay before ever even getting into the interview room?
No.
Do you recall during the interview when you told her it was Tay, you told her, I gave you a picture of him?
I don't recall.
And do you recall her pulling up the picture and showing you the picture in the interview on her phone?
I recall her showing me a picture of him.
And do you recall not really want to point him out on there?
Because I knew at that point what she was doing. They was forcing me to say it was him who shot me. Because I like I keep telling you now, and to this day, I still feel as in they did that. Like I never seen him shoot at me. Even when they called me, tried to get me to come to trial on it, I told them I'm not coming to trial because I never saw who shot at us. And they said, well, Mr. Copeland, we don't, all right, y'all can call me. I didn't see who shot at me.
Were you concerned about being labeled a snitch because of what was happening to your cousin?
My only concern was not being able to protect my family.
Do you recall telling Detective Gaither that you were concerned because your cousin was being tortured because he was labeled a snitch?
My only concern was being in jail and not able to protect my family.
Okay. Do you recall telling Detective Gaither in referencing your cousin, well, he's getting tortured. Everywhere he goes, he's a fucking rat. So nobody want him around, this and that. And then he turned right around and I'm in the same damn shoes he's in, but I won't. I don't know if he did whatever he had going on, but you didn't want to be labeled a snitch.
This is the police talking to me, and they're not trying to hear what I'm saying. They're trying to force me to say that somebody shot at me that I did not see shoot at me. I am trying everything in my power to not lie on this man. I'm not here to protect nobody that shot at me and my child.
Okay. Did you ever give Gaither the gun that you used in the to shoot back at those individuals who shot at you and your child
No.
Why not?
Cause you gonna use it against me.
Who did you get the gun from?
What you mean? Who I got it from?
Who did you get the gun?
I sustain the objection.
Do you recall being shown a photographic lineup with Tay inside of the photographic lineup?
Say that again.
In this interview, do you recall being shown a photographic lineup?
I think so.
Okay. And do you recall not wanting to sign the photographic lineup?
Right. I do remember.
Okay. Why didn't you want to sign the photographic lineup?
Because in my heart and from facts, I didn't see who shot at me, and they constantly kept trying to say, they kept pushing me to say, to make me think that I saw somebody I know I didn't see.
All right. I want to kind of switch gears. Do you know someone by the name of Trivia?
Who?
Trivia.
Who is that?
Do you know someone by the name of Trivia? Do you know who Moontunk's girlfriend was back in 2015?
No, I don't remember who his girlfriend is.
Okay. Do you know someone by the name of Aunt Trivia?
I never heard the name before. I don't know.
Okay. Do you recall talking to a Detective Lewis in the same interview regarding Trivia being Kel and Moontunk's girlfriend?
Oh, her? What about her?
So my question is, so do you now know who Trivia is?
Yeah, I know you're talking about.
Okay. And back in 2015, do you recall her home being shot up during the time of early 2015?
I remember.
Okay. And were you accused of shooting up her home?
That's what she told the police?
Did you shoot up her home?
No.
In the 3 interviews we've talked about so far, were you asked by the investigators to tell the truth? In the interviews we've talked about so far?
It don't matter.
Yes or no? Do you recall being asked to tell the truth?
I don't know. I don't
God
recall.
bless you. God bless you. You don't recall if you were asked to tell the
I
truth?
don't.
If you were asked to tell the truth, why wouldn't you tell the truth in those interviews?
Why wouldn't I tell the truth?
Yes.
Because I know the police are trying to lock me up.
What would they be trying to lock you up for?
Say that again?
What would they be trying to lock you up for?
Whatever they can put on me.
Did you ever? Now, Would that still be considered a prior inconsistent statement? And Your Honor, I have three cases for the court.
Okay.
I have Green v. State, and I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Sconners v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS, v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes,
Your Honor?
thank you.
Oh, sorry, and I'll give it to you. Give me 1 second.
Thank you.
I gave you green already, Mr. Warren. I gave you green already. Which one did I give you? Okay, you're welcome. You're welcome.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the only one I've looked at so far, is there one that says, if you say, yeah, that was a total lie?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officer interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said a witness's failure to remember making
All
a
right, so hang on. You're talking too fast for the court reporter to
Sorry.
take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court, the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia 63 at 66, pages 66 through 67. They further cite Bridgewater, which is 309 Georgia at Penn site 887. Which cited defendants denied recollection of making a statement, provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Sconyers that discusses primarily that the state does not now have to go through every single inconsistency,
Okay.
but that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
All right.
And then Oldham, Your Honor, is a federal case on the same point as the Green case, Your
Okay,
Honor.
thank you. Appreciate it. Counter law, counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Max Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't because we
Right. No, I mean, I don't think anybody
we're-
disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true. Yes, he may get up there. Who knows what he's going to say? But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was according to y'all, and I've seen some of it, that was a complete lie. Then we will face this, and so let's figure out what the...
So we're guessing at what you may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
And if for anything, I do remember that there were at least 2 full days of testimony from the 10th to the 12th. And it's the state's remembrance that the I live started early in his testimony. So,
Okay.
but we can
Thank you.
deal with that as well.
And with regard to that, the court reporter has said that she probably, what did she say, Ms. Hurstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said by either late today or tomorrow morning, she should have, I believe it's June 10th, June 11th, and then we'll be working on June 12th shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked
Okay.
3 questions in that.
All right. So do we already have the 10th somewhere? We'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember, reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, I'd be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement, quote, lies to try to get out of trouble, unquote, and that he would, quote, say anything, unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said
Okay.
23, I meant. Prior inconsistent statement.
Okay,
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or
Right.
testimony by contradiction. So I found this case, if you don't mind pulling up,
Okay.
or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says
okay,
over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that the particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pretrial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's the, I don't want to mislead the court, it's under the former
right.
24-983. Then I looked at Cummings, which is cited, which is Cummings versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just like refuses to answer whatsoever.
Exactly, which
Okay.
is really obviously, saying I don't remember, I don't recall, I don't, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to arm you with it. But then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green, Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure. Yeah, absolutely.
Thank you.
All right. Thank you. Thank you, Ms. Hilton. That was a helpful use of our break. All right. So with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously
Okay.
discussed with Judge Glanville for the states as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
It was what was
or
hashed out during.
the state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done, 3 of them were definitely done after the recusal motion was filed.
Okay, well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing 2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. And I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make a,
Yes,
come
Your
to
Honor.
agreement on.
And we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So,
All right, I'm not sure I follow you.
Okay.
So. What you say you want to revisit.
so
So I think first it would be helpful to know which ones were hashed out before the recusal motion. And then we can just say that's what we're going with because that was prior to any issue. And therefore we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, or I mean, I thought y'all wanted to figure out what was actually done and what wasn't.
and I guess maybe I misinterpreted what I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based upon what occurred.
All right.
And so that's what I thought I understood.
Okay, and that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before. And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody yet. Is that true?
No, we did hash out that one as well.
Oh, you just
I just wanted to,
you want to revisit that one?
yes, Your Honor.
Okay. Okay. All right. Can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those
and respectfully, and I'm not trying to belabor the point, but just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post-serving the recusal motion at this time.
Okay.
So
well,
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is I have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th. Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time. Okay. So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
I'm sorry I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Short just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Short is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now.
All right. So, here she's going to try to get more of her scheduling speech in and admonish about why she wants things done on time. And she's going to do her taskmaster rendition again. But meanwhile, keep in mind, the brothers have been working. What have they been working on? The stuff that she ran through yesterday, Speedy Gonzalez, so they weren't expecting everything to just be blown over the way that it was. And then, okay, let's get to work on the rest of the stuff. There wasn't supposed to be a rest of this stuff, right? That's like plan D, right? Plan A, B, and C though. Hey, mistrial, get some bonds. Let's get, there's enough stuff to talk about this. We might not even get through this in a week or two, the stuff we got to talk about. Even if you grant one bond hearing, anything, come on now. So no, they don't have the Lil Woody video that they've got all the notes ready to go for that. For what? That ain't where their mind is. But because she blew through everything, so they like, yo, I mean, we wouldn't even. I ain't thinking about no Lil Woody video when I'm trying to get the mistrial based on the ex partes, based on what just happened, based on the recusal, based on this, based on that. I mean, just like Weinstein came with the motion, boom, just like that after he got the transcript from the other ex parte that led up to the ex parte, right? I mean, these cats will work. They going, right? Hardcore. But she just blasting through them so fast. It's like, yo, what is this? So I get it, I mean, that ain't what they was trying to do. And what they did do, they expected to take more time with it. So with Brother Adams and the rest, this is another way they can slow this thing down. So I'm like, hey, my notes ain't even here for that, So she's going to get more and more frustrated, but that's okay. So what? We ain't here for you. Rhodes, dogs, and conversation. That's right. I said it. We ain't here for you. We're here for our client. You gonna go on to the next case regardless. My job, what I do, I fight for my client. That's what I went to school for. That's what, I supported my wife through law school, or she supported me through law school, whatever the case is, right? This is family time. I've missed soccer matches. I've missed baseball games. I'm probably working for very, very cheap right now because this case has been going on forever. And my guy didn't have that much money to begin with, and so I'm still here fighting for him. I'm here for my guy. I could care less. You gonna go on. So, I was to be deferential with you. Again, brother says I'm role playing, right? I'm not the attorney. I'm role playing. But I'm going through all this with you. Nah. I'm here for my guy. I can't even get a bond from a guy. I'm being nice to you and deferential because this is new. This is, we trying to get through the honeymoon process. This is new between us. So I'm trying to be cool. But I can see that's not working. You're going to take me just being cool and just keep running over stuff. So, hey, let's pump these brakes and see if, giving you some spice, giving you a little funk, see if that wakes you up a little bit. But something going to have to click. And brother sisters, what do we say? I mean, I told you that yesterday, right up front. Somebody got to slow this train down. Quick. Y'all better figure it out. Rhodes, dogs, and conversation. Thank you for being here, brothers and sisters. We appreciate you. A little bit of education and entertainment at the same time. What you know about that? Smash that like button. We appreciate you being here. But yeah, so let's go back to her. Clearly she's getting more frustrated because she wants to, have her schedule met. Well, let's see. Let us know what you think. Appreciate you being here. Rhodes, dogs, and conversation.
And then we're going to move to evidence. Y'all should have used that 10 days to be doing this because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have you then make better use of your time up until now. But y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So. Okay. All right. So how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Zachary, starting Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over, well, we have turned over the statements that Mr. Zachary.
Okay, brothers and sisters, she's just stuck. So let me just say it right here, right now. Whitaker is stuck. She does not know what to do right now. She's realizing that she can't just, she did what she could do, right? Which is blast through the stuff that was in front of her, right? But now she can't force them to have things prepared that they don't have prepared. So now she's stuck. She can't just blast through it. The junk ain't ready. What's she going to do? She's in trouble right here. And the anxiety of her keeping the trains run on time. I mean, she may just send them for an early lunch right now so she can even gather herself and come up with a plan. I mean, you know, this is, but now the same way I'm saying, if this is what you want, she's a master scheduler, a master conductor, keeping the train on the tracks. Okay, then she's in a very difficult spot because she's realizing that she can't control mess with just saying, let's go faster. You're going to have to deal with these things. And there's too many people in the room and they're too smart. So we're about to see her own nature of go, get it done, more, do something. We're about to see that collide with mess. Hear what I'm telling you, brothers and sisters. Let's check it out.
Zachary has made.
All right.
The belief that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what he's going to do.
Okay. So for a whole lot of this, I mean, y'all can't really, let's assume that he testifies. Let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling. But if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And with the court, is the court asking for a copy of each of his statements? Because we can't provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7, lines whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court, I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary? Anybody? Does everybody have Mr. Zachary's statements? Yes. Okay.
I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
Y'all are
has.
all old like me and you like paper.
Yeah, and because we have our notes on the paper too, and so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today, so
Yeah.
I didn't bring the transcripts with all my
Yeah,
notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but
Understood.
okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and other witnesses that you're going to be getting to soon?
We have been, not entirely, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't believe that we have any jail calls from Quindarius Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls for Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use. And then they can say, only look at those. Here are the objections we have.
I can do that. I have not broken it apart.
Okay.
Segment science.
Okay.
As
All right.
I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What we can do as a prosecution team, over the next, however amount of time the court wishes to allow us, is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some of them.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that. Yes.
I said it, so
You did say it.
You know, there we go. But I overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now?
It's not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements
Right.
issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit
Okay.
during the course of the trial.
Okay.
That notice was filed on or about by the state on or about, excuse me, November 3rd
Okay.
of last
23.
year,
Okay.
obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same. They only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay. Understood.
So I want to get that on the record. And finally, you know, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever
Right.
that I want to reallege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that for, I know that all 6 of the defendants here are charged in count one, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, you know, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, this does go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you
Okay.
with that, whether you ultimately do that or not.
Yeah,
this is
I don't
what
know.
we've
I'll
been
hear from
arguing.
both sides. But
Yeah, it's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right, so we'll get you that
Okay.
soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. But does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801 D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay,
Yes.
and then you're saying there's another one?
Yes, that's November, that was filed on November 30th of 2022.
Okay. And give me a second, Laura.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang Act trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen...
We'll jump right back into that, brothers and sisters. We'll jump right back into that. But shout out to Brother Glanville. Now, this might sound a little weird. It might sound a little weird. I'm going to give you that, okay? But shout out to Brother Glanville, and here's why. No. Was he on time? No. Did he say 5-minute comfort break and it turned into 45 minutes? Easy. Yes. All that was terrible, waste of time. Okay, we all agree. But one thing he did do, and again, this might sound a little weird. Yes, she's better at scheduling. Yes, she's better at being more efficient. Yes, she's better at being punctual and all that. Okay. Blah, 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 blah. With those negatives that we talked about, so she's just quickly dismissing stuff that maybe should take more time. All right. So that aside, but shout out to Brother Glanville. And here's why. If this was you right now and you saw all of this different stuff, and over 100 witnesses, and for each one of these you have to go through 1,000 things, right? You're gonna have all these objections and this and that. You're dealing with RICO and all these different attorneys, and the different counts don't apply, and this goes to that, this goes to that. This other person wants to be separated over here, etc. You got all that going on, right? Can't you see how Brother Glanville was just like, yo, well, we'll get to some of that later. Let's just go with what we got right now and let's get going. And as we get to that, we'll deal with that. Versus us spending 30 days thinking about this. It would be nice to have all this done ahead of time. Maybe that's the normal way of doing it. But can't you see how Glanville was like, yo, look, okay, I get it. Look, who we dealing with this week? All right, let's knock this out. And that stuff going on with number 29, witness number 29. Yeah, we'll get to that cat down the line. But right now, let's get to work. We know we got going on this week. Let's focus on that. Let's go. I can see that. You see what I'm saying? I can see that. Because like what she's saying to Love, oh, well, you could give me everything? 100 witnesses? Okay, well, you can give me 30? You can give me 30? Okay, great. Let's go. Give me the 30. 30 witnesses? 30 statements? I mean, yeah, I understand in the normal run of things, discovery everybody has, it's already been given to each side. So they have the information, supposedly, most of it, right? Because that was part of the other motion, right? That everything hasn't been given over. But let's just say, basically, they have it. Because even Sharp said, we have the stuff, but we got to go through the stuff. And there's thousands, right? So, hey, we have it, but we have to go through it. Okay, so it's not that it hasn't been given. But we haven't went through all these many hours of stuff, picking through it with a fine-tooth comb, because we were doing the fine-tooth comb on what was in front of us right now. The dude that's coming up today, we are analyzing every word, objecting to the video, objecting to the jail call, etc., point by point by point by point, right here, right now. And that takes full concentration because we're trying to get our guys off. Plus, we're dealing with what we feel is an impartial juror, a judge, et cetera, et cetera. So, hey, we focused. No. I need to think all the way through it. I need to hear everything. I need to hear all objections right now so we can just boom, 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 boom. Well, dang. So witness number 75, I got to give you all my objections right now? Well, no, just hypothetical, at least so that we want to deal with. That's what lemony is. So just give me the she is just trying to run it like that. I get it. I don't think it's going to work the way she thinks it's going to work, which clearly it's not. But okay. But shout out to Brother Glanville. Because as bad as he was with the time, hey, he was doing stuff. We were going through. We were getting to cats. And we did go from witness to witness. So we were rolling. Kind of jankly, but we were rolling. So maybe it wasn't a bad strategy all together. Let us know what you think. Rhodes Dogs in Conversation. Thank you for being here. Smash that like button. Let us hear from you. What do you think?
Come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial or in the presence of a defendant currently on trial that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
Okay.
Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide.
Sorry, when you say in this particular notice, which notice?
The November 6th, 2023 notice.
Okay. November 6th. November 3rd?
It's just, he said it wrong.
It's filed.
November, okay. You provided notice of 3 different statements.
Right. 3
right?
specific ones.
Okay. Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are, just one moment.
All right.
And so that we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can
Yeah,
send it to
because
the
y'all,
court.
there are a lot of filings
We can
in
send
this
it to the court.
case. But Ms. Percifield has saved it for me somewhere, but there are already a lot of things in our file also.
We'll
So,
send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it? Is emailing it to me because I need lots of assistance. Thank you, Laura. And so was there an order at some point or a direction from the judge to tell the defense which statements you believed to be co-conspirator statements that led to this supplement? Yes. Okay. I mean, if there was, that's all I need to know. So yes. So, okay. Now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay. So they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement. We intend to use it.
Yes.
Okay, well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands
Yeah,
of jail calls involving dozens of people.
yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified, I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators, why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact, that'll be for the jury to determine, but there's a preponderance from which I can determine. Okay. All right. So who do you know of right now?
Hold on, 1 second.
Okay. She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
And so that the court knows what I'm doing, I overheated. And so I had to wait.
By which you mean your laptop overheated.
I mean my laptop. And I was
Because I've told y'all not to overheat anymore.
So that's what's
okay
happening.
Yes, sir.
While she's waiting for that to
Sure.
come up, could I just briefly address a side issue?
Sure.
When we met for the status conference, I
Yes.
believe Mr. Harvey asked you if you would support us when other
Yes,
judges try to
I
drag
recall
us in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, oh, I'd like Mr. Harvey for trial. And I said, no, you can't have him. So
Thank you so much,
Yeah,
Your Honor.
mhm.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that.
Mm-hmm.
So you were referencing that week last week where we were out and why we weren't working to prepare
Right,
for this.
right.
I was being called into court all over the state of Georgia.
Sure, I'd imagine.
And maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation
Yeah.
to do for this week.
Uh-huh.
But unfortunately, I was hauled over all over the state.
right. And we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we can work on this trial during those breaks?
Because, I mean, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on a case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for,
Yeah,
just for myself.
I mean, let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer. Right
Okay,
now.
thank you.
Okay. All right. How long are you going to need? 2 minutes, 10 minutes, 1 minute? Okay.
This is utterly ridiculous for so many reasons. Ladies and gentlemen, brothers and sisters, I'm telling you, this is what I'm going to bring up something we said yesterday on top of everything else that we've already discussed with you. Just throw it at you again. All right, so where's your adaptation skill, right? So again, where's the team of high-powered attorneys from the state, as in Fani, that are now in this room helping Atkins, Hilton, and Love? I mean, big time support. You see what you're up against now, and you know you can't handle it. You're just completely overwhelmed, and with Whip Flash, Super Speedy, Whitaker, you got to do something. So where's your play? Where's your play? So I blame them. You know, the same way I'm talking about the defense is adapting and finding a way to push for their client, finding a way to slow Whitaker down. Yeah. The state is just getting smacked around again. And it's going to get worse and worse and worse because Whitaker's going to continue to pound them. Because right now we're still in the state's case in chief. So it's still going to be the state's responsibility to present these things to keep things rolling. The defense can just object. But they're not presenting the witnesses right now. They're not presenting the evidence right now. So the fact that the state doesn't have this stuff ready to go, it's a problem. It's a problem, especially with Speedy Whitaker.
Your Honor, we're going to allow Mr. Atkins to stand up and give to the court the calls that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
One of the wiretaps.
And Your Honor, this wiretap is it's a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of getting, I wanted for the defense to know where this specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties.
Okay.
To take off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
Ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document that has the date, time, reference number.
I would think that would be
PDF
easier
page.
for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with is Demekion Garlington, who is a severed co-defendant.
Right. Okay.
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay.
For this particular portion.
Okay. All right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who is
is-
also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So
case.
you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor.
Okay.
Yes, Your
All
Honor.
right, Sumlin. And you can do the same for him.
Correct.
Okay,
And
perfect.
he has less, it's hard for me to ballpark the number.
That's
for
fine.
him,
I
but
just was like, if it's two, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay, all right. So that is two further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay.
That's a part of the 5,
Jail calls.
about a
Okay.
portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in? Okay, that was part of the notice, so that one's good.
I don't think it's a part of notice, but
They don't think that was part of the notice, but they're willing for y'all to say that's good.
but there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and, all right, well, you've already been litigating that, so I'm gonna call that one good in terms of notice. Whom else? All right, question. So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay. Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right. Can you provide to this judge whatever that supplement was so that I know? Thank you. Do y'all, deputies, do you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do you actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
This is a quick question.
Yep.
I can't, I'm having a hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay.
I'll look for that. I'll look for that.
During
the law
lunch.
that I referenced where it said that you can't use.
Okay.
the matter of-
That'll be great. Thank you. All right, we're in recess.
All right, brothers and sisters, we will allow this mess to continue to develop on its own impetus. It's pretty bad. Not really must-see TV now with this style of get down to the get down. What do you say we throw on some music and jam a little bit? What do you think? Sound good? Music during lunch? All right, we can do that. Good idea. Y'all are so smart. Yeah, let's do some jamming. We got to have something going on because Speedy Whitaker is, got the flow all jacked up in more ways than one. All right, brothers, sisters, Rhodes, dogs, and conversation. Shout out to Miss Mod. Check out the chat. Lots of great information in the chat for you. Check it out. Stuff that you can get a little deep on this stuff and, begin to think about these things in different ways and personalize who you're looking at. We can start talking about the issues on higher levels. So check out the chat. Good information over there. Shout out to Miss Mod. All right, let's get to grooving.
Check the mic and make sure it sound right, boys. It sound right, boys. It sound right, boys. It sound right, boy.
Hope everybody had a good lunch. So what were we able to sort out with regard to other potential co-conspirator statements? Identifying those.
We have a list of potential ones.
Okay.
Sort of a broader universe. And I'd like to narrow them down before handing them over. Some of them we have reviewed and they have statements about drugs that we may not want to introduce. So there's a large volume of, for instance, calls that have certain commentary in them.
Okay. So you can identify the statements and you're saying that it may be less than the full statement and you can further narrow that, but you at least at this point have the person and their statements.
Yes.
Okay.
Up to a point, yes. Oh.
Okay. Up to what? You can go ahead and continue to explain.
So, and that's the way it is with a number of the jail calls and the calls from the wiretaps that we have reviewed so
Okay.
far.
Okay.
We have, there are some that are left unreviewed, but the ones that we reviewed.
Okay. And for the ones that are left unreviewed, can you identify, here's the person and here's their universe of statements? We just can't tell you what portions yet? Do you understand what I'm asking?
I think I do, and I don't think that you can. When you said, if you could just clarify.
Okay, so why don't you do what you can right now, and then I'll ask you the rest of it. So as to what you have prepared, let's go ahead and share that.
So this, in much in the way that Mr. Atkins was a list of
Right.
54 comments,
Okay.
it's similar. It contains
You don't have to count the number. You can just go ahead and give them the notice. Is it something that you have like a written list?
So yes, it's
Okay.
it's an internal list of notes
Okay.
and calls that are identified.
Okay.
So what I can do is provide to them just the calls that are identified.
Okay, so do you want to do that in writing? Okay, so do you want, could you at least in court identify the witnesses?
So when you say the witnesses, you mean who we're going to introduce?
No, that's not what I mean. I mean, who is the alleged co-conspirator who's...
Okay, welcome back, brothers and sisters, and we're going over the same thing. Whitaker has an insatiable need to get something done, and the state is unprepared for what she's asking. So it's just ridiculous. It's just ridiculous. Again, the state needs way more help, and whether or not it's their fault, the lawyers in question, whether Love and Hilton and Atkins actually had enough time in all these months, who knows, right? Who knows? But at this point, clearly they're overwhelmed. They're losing. It's a bad scene. So where's the reinforcements? I mean, I'm already on that. Just where are the reinforcements? You know, whether or not they should have had this stuff, or, you know, based on how they were dealing with Glanville, they didn't need to have it like this. So whatever, It's jacked up. Get it. Okay. But what Speedy's trying to do, they're not ready. They're not ready. And she's just, well, let's just do something. Well, let's just do something. And that's problematic. If Woody's going to be the next cat up, right, then maybe the move should have been, instead of, well, just give us somebody, we'll just bring up somebody. No, when you took that little break, it should have been still focused on what do we need to do to make sure that we have him taken care of. So on Monday, we can go with him if that's what we're going to do with the jury being present on their first day back. If that's it, and we know Hilton's not even going to be here, so we have to handle, if Love's going to be the person, so still you're chopping down the order. And that's why I said shout out to Glanville, because as jacked up as it was, at least he was saying, what's in front of us? Let's tie this up and get past this person or get past this thing, tie it all up and move on. Right. But right now she's just spotting. She's just saying, hey, anybody tell me anything? Let's just do something. Well, something. What is something? There's still an order here. And what she's asking for takes a lot of time. And should these people have already done that? Maybe, but they're not ready. So what are you going to do? What are you going to do? And then once you do all of this other stuff, now who's getting ready for Lil Woody on Monday? If that's what's going to happen, with the jury coming back. So just doing something is not even preparing for what's right in front of you. Plus, what about these other motions we have? So it's all coming together as a big mess, to the point where if she keeps going the way she's going to start looking in the mirror and saying, do I really want this? A person who has an insatiable need for order, and if they realize what she's about to realize, if she hasn't already, that she does not have the power she thinks she has to fix this. Okay. So now it's okay. What did I just get myself into? I'm dealing with these cats and I can see this is going to be problem after problem. Exactly. That's exactly right. That's why at Rhodes, Dogs, and Conversation, we first titled this thing as The Foolishness. We saw that from day one. That's the way we came. This is foolishness. So we already understood. Now, I guess she needs to catch up to the fact that she can't fix it because she's not doing the homework. We already seen how she does it. Go through it and just boom, 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 whether she's getting it right or not, just boom, boom, like checklist, right? But she can't do their work for them. So there's going to be an obvious roadblock. She can't work for the state. Ethically, that is, right? So this stuff has to be done. So, okay, fine. Where's the backup? Where are the soldiers to come in and jump in and get this stuff done? All right. I mean, hey, we're not loaning out Miss Mod. So you're in trouble. I mean, Miss Mod come in there and do, hook it up for you. But hey, we need Miss Mod over here. So, y'all just in trouble.
Statement you think you're going to use. And if you have the witness you're going to use, I get it in through, that's great too. But we're looking for co-conspirator statements. So we need to know the ID of the co-conspirator.
So mainly the ones from the Garlington wiretap are the ones that are identified in a majority. That's the ones that we have the majority of. The remaining jail calls that we've identified, they are jail calls of Diamante Kendrick, Martinez Arnold, Shannon Jackson, all of whom are actual defendants who either are currently in trial or who have pleaded, and Lamar Nichols.
Sorry, I just couldn't
Okay.
hear it. And number.
Is your mic on?
My original objection was too little, too late. In other words,
I understand.
okay.
I'm just
so-
trying to sort out what there even potentially is at this point, and then, which is harder than it should be. And then I will hear why it hasn't been shared before and why it should now be permitted regardless.
Thank you.
Thank you. So can you say those four people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendricks, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
If I may respond to that, if it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later, you should, without any question at all, exclude those. I mean, this is,
Okay.
come on, 2 years later.
It is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing now is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it has yet to be identified as a potential co-conspirator statement. So with regard to your objection about not having it, you have it, it sounds like. Now, if it's a statement of one of the defendants on trial right now, but it is going to be used against another one of the defendants on trial right now, it is, right?
Yes.
Then it is a co-conspirator statement. So, Mr. Nichols, Mr. Kendrick, Mr. Stillwell, you also said Mr. Arnold and Mr. Jackson. And did you say that both of those people have pled?
Mr. Arnold has pled.
Okay.
And I said Jackson, but Jackson is Stillwell, so that was
okay.
a statement.
All right. So the only person you've identified other than the three that are on trial right now is Mr. Arnold who pled.
Right. And there's also Nichols, Kendrick, Stillwell. And I have a jail call from Quindarius Zachary.
Okay.
We've identified.
That you've identified only now, not previously. So don't tell me that the three that were already identified, they don't have an issue with in terms of it. Late notice, yes. So was Zachary one of the people that had been identified in that November 2023 notice? Because the notice I have says person A, person B, so I don't know who they are.
Right. So not the jail call, the statements that he has made, but not the jail call. So the name, I believe Zachary is either A, B, or C. I have to look at our notice.
Doesn't matter who. Yes, he was identified as one of the people whose co-conspirator statements you intended to introduce, but the jail call wasn't identified within there?
That is my.
Okay. Is the jail call subsequent to the time that you provided the notice?
No, the jail call date is 2015. It's in 2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
When we were preparing the notice, our understanding of the need to extract jail calls that contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirator statements.
Okay. Can somebody provide me either the order, oral or written, or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation?
And we're going to
Okay.
get that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing commentary about the jail calls and the number of them and identifying them. So we were still listening to
Okay. So at some point, presumably you completed your listening. I mean, I know they're still ongoing, so I'm not talking about a jail call somebody did last night. But
even
okay.
all of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question instead. Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have co-conspirator statements for that you are potentially going to want to admit in this trial? And let me direct your attention to, because this might help you a little bit. You, a couple of days ago, provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go. All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a piece of evidence? All right. So if everybody wants to follow along and pull out your state's witness list, the first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator. And then on your evidence, you have listed a defendant interview and a jail call. Right. Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these, I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay. And then Arnold, who's number 27, you mentioned. How about number 35, Woony Lee, who you have labeled as a co-conspirator?
He is.
Okay, and are there potentially co-conspirator statements from him?
So unless what we have of Woony Lee consists of social media evidence. So arguably, if that could be considered co-conspirator statement.
Say better to say, yes, I think so, and it not be than the other way around at this point. I think it was 35, 33. Says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
And Your Honor, for the record, it added 2 custodian records for
Okay.
Sprint and T-Mobile.
Okay. So anyway, Woody Lee, either number 33 or 35. How about, and you mentioned Sumlin earlier this morning, and Sumlin y'all already had notice of from November of 2023. So Sumlin's okay. I mean, that may be it in terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them.
Okay.
Would be
All right.
considered co-conspirators.
All right. And I think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other. It still might be helpful to identify the statements, but with regard to deficiency of notice as to those people, I'm going to say that's okay, that's kind of within the context of there being a RICO count against them all. That notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that that is accurate. I want to be accurate before I say that that is accurate.
So while she's making sure she's being accurate now, somebody else can tell me, so on the notice that is from November of 2023, the two people are they, who are Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point. I mean, y'all know at this point. So how about somebody on the defense side tell me? And you don't even have to say who's who, just. Ms. Weinstein, you're looking at me like, I know, but.
Like, this seems like a job for Max Sharp.
Apparently it is, because here he comes.
I'm looking at, am I correct that you're asking about this notice of the three?
Yeah, there's a like, I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So.
So, Your Honor, witness A was Mr. Copeland, and in that notice, we
okay.
talk about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quindarius Zachary.
Okay. All right.
And he's talking about statements that were made by
all right.
Defendant Stillwell and Defendant Kendrick.
Okay.
And
yes,
and I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
I think it says Donovan Thomas Sr. to his brother, but that wasn't co-conspirator.
There's an A and a B that are like not identified people, right? Okay. Okay.
But 3 is not a co-conspirator statement, correct? Okay, so there's only 2 co-conspirators, alleged co-conspirators.
Okay. All right. So with regard then to
Damone Blaylock, Your Honor, there are statements that are made, well, there's social media that we have identified. Damone Blaylock is a defendant in this case who's been severed.
Severed, okay.
He, social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay. And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, Woody Lee, he resolved this case.
Okay. But I mean, he was at one point part of this indictment, the big indictment. Okay. All right. So then really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come as no surprise that the state thinks they are co-conspirators because the state literally alleged that in the indictment. So at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce? Go ahead.
Your Honor, not certain what amount of time the court's willing to allow us to identify anything not already identified or in the indictment. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify within the discovery already provided.
Right.
Identify specific statements that are there. We would ask for a week to identify that.
All right. Understanding, Mr. Harvey, your objection to delayed notice, I am going to overrule that objection right now to the admission of the evidence. We, of course, still need to know what the actual evidence is. And a part of the basis for me overruling that is that it appears that the whole trial has kind of been operating on a rolling basis with regard to the evidence. And there have been orders even that, hey, you know, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then so be it. But I want that to stop right now, which is why we are going through in what I consider to be painstaking detail, because this really should not be what the court is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, you know, blind, or practically blind. So now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense. Okay. You look like you want to say something, Mr. Steele. Okay. All right, you're welcome. Okay. So, what else can we get done today?
Your Honor, just to address a matter that the court asked me about before lunch. The court had asked, when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said something akin to that.
Yeah, and you said you had some kind of law that you could provide to us.
What I referred to was Georgia Uniform Superior Court Rule 25.6 and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last 2 lines of the rules say that if a motion to recuse is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is, cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence. and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
Well, it's not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I mean, I was, as to relevance, that was
Okay.
why I was saying.
All right, so relevance will be a separate issue from whether it is, and I can already anticipate the argument, because I would make this argument. What you just read says any other case or proceedings. What does that mean for the case that it happens in? So I think we probably need a little bit more research.
And that is what I sought to do over the lunch hour, but I did not find any Georgia case law that elaborated on, I didn't find any case law that elaborated on that. And so that was,
all right.
That was where I stood.
Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency wise or relevance wise, although I think I pretty fully understand the defense argument on it, but okay, thank you. So I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already. So we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of? Yeah.
I'm a little confused.
It's not even showing that I have a message, but okay. So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements, we've been talking about Mr. Quindarius Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements.
Right.
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught Nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught Nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge.
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that two defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the answer is no, it's not just those two.
right. It's the whole state.
No, it's not just those two.
Right.
It's
Well,
all-
some of
And
this
so,
my understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking the stand. So him That's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking a stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those two statements, which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that I have not been identified specifically.
The statements that the statements that Quindarius Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
All right. So I think I hear you saying that with regard to anybody named with at least one count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them, yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement
not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, we're on trial. So.
Right, but they're co-indictees.
Yes.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements?
No.
Or are you going to break it down further within the next week?
We will break it down further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who were not indicted, that fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical, the theoretical to the reality.
Yep.
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in a room with Mr. Zachary and his attorney. the district attorney, excuse me, you're really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house. And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of the shooting of the convenience store on Cleveland. I'm just making this up.
Yeah,
Cleveland
sure.
Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding. And there's no real. These aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
Right. So
and
you
everything
need
else.
to know in
Right.
more detail.
Who
Is
the
the
source
state,
is.
well, is the state planning to use, I think Shannon did that.
Right.
Is that
and-
what you want to know so that we can then drill down on, is there any basis for that coming in?
Right. I need
that
to
what
know
you mean?
what the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr.
Okay.
Huey, but there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure. Okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source. If it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay. All right. So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good. So I don't have an agenda anymore. My agenda got hijacked. What else can we do that's productive today? Anybody have any ideas? Mr. Steele. Okay.
I could get you brief very fast, but I argued this before the recused judge and it was denied. Former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost, and then the Supreme Court of Georgia denied cert.
Okay.
But there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it. Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since we don't have anything else to do right now. Okay.
So in count 56,
You know what? Let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Give me a minute.
It's page,
Okay, got it. Page 90.
okay, so that charge is Mr. Williams. I'm just using this as an example.
Oh,
It
okay.
repeats a charges Mr. Williams with participation in criminal street gang activity. And it gives a date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of a criminal street gang. YSL didn't.
Okay, brothers and sisters, word to the wise. Whitaker has admitted that hijacked is the word she used. Her schedule's been hijacked. Basically, she doesn't know what to do. She doesn't know where she is. She doesn't know how to progress. And she still has this addiction to just getting stuff done regardless. Brother Steele, noticing that she's totally without a plan, has no answer for where to go. He says, well, hey, since we got a few minutes, I'll throw this at you. And if we heard right, he's already said even the Supreme Court of Georgia has already denied. I mean, he listed it out. He says there's already a ruling and everybody's denied. Glanville denied. I took it up. They denied. I took it up. They denied, So he's already said, everybody's looked at this, has already said, heck no. Now, do you want to hear it? And because she has such a need to just do something with the cameras rolling and with a court full of highly advanced, skilled attorneys, instead of her just saying, there's so much stuff that needs to happen, y'all just spend the rest of the day working and we'll pick it up tomorrow. She couldn't do it. She couldn't just release them to work. Say, hey, this is in-house suspension. I don't want nobody leaving here until 5 o'clock. Get to work. Get to work. Because this is ridiculous. Get to work. Nope. She just has to do something. All right. Now, she's opening herself up to who knows what right now. Hey, look, she may end up putting herself in a position. You understand what I'm saying to you? Steele has already told her a bunch of folks who know the case better than she does, who have looked at whatever he's talking about, have looked at it and denied it. And now he's putting it on her and she's accepting to listen to it. All right. With your bad self. Now, keep that in the back of your mind. But also something we've been saying about, this, how she's running into the mess. Let's go back to her looking in the mirror. It could come a time when she looks in the mirror and says, do I really need this in my life? Hear me, brothers and sisters. Hear me, brothers and sisters. Do I really need this in my life? There's got to be at least one of these motions for mistrial that makes sense. I can get out of this thing. Holla if you hear me. Holla if you hear me. Put a pin in that, Miss Mod. And that's where it's at. Now, she may tough it out because the cameras are rolling. She may tough it out. But she going to be doing some self-check real quick in the mirror. Like, hey, I can't control this. This is absolutely ridiculous. And all I've got to say is, yeah, I can even see it's so ridiculous that the defendants obviously can't get a fair trial out of this mess. There's enough dysfunction. There's enough stuff going left and right and every which way. I can't in good conscience continue to deny bond. I can't in good conscience continue to watch this thing be as dysfunctional as it is, knowing that it's not going to be fixed in anytime soon, and in any way where I can feel that the defendants are getting a fair trial, or even the state. She could even, even the state is being represented properly. She could say that. There are lots of ways out of this thing. Clearly, lots of ways out of this one. But if she wants to tough it out, yeah, you gonna see. This thing can age you. Don't be surprised if she got a bunch of gray hair soon. Rhodes, dogs, and conversation. Don't be surprised.
engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking, and motor vehicle. Sorry, I apologize, Ms. Winfrey. Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022, while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm, and possession of a weapon by a convicted felon contrary to the law. The state, good order, peace, dignity thereof. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements. And that would be pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue.
Okay.
But they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it, and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 U.S. 246 at 252, 1952. It's also explained in Elonis, ELONIS versus United States, 575 U.S. 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723.
Okay,
That's 734. It's a 2015 case.
okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang. That became an essential element. That changed our jury pattern instruction. And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks at 24, there's 418 kicks in. But I believe that the charges for the gang is not appropriate. I
And
wrote,
did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
they didn't take it up.
They didn't take it up,
I
okay.
didn't get under Dukes, D-U-K-E-S. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never
I
did.
thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and.
Did not, they said it's not a collateral order. I
Okay,
needed a
all right. So they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up?
And
Okay,
then they dismissed the appeal. So there's no
right,
rule of the case.
okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promised that.
Okay.
in those
And
two counts.
are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an essential element in count 1,
Okay.
which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse.
Uh-huh.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that's RICO conspiracy count starts, I think, at page 12, but hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment. But no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No, I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in that, in
Okay.
count 1.
Okay.
RICO conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who are here, also the others who are not here, unlawfully conspired to acquire and maintain directly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is C-O-T-M-A-N versus State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case. That is a teacher from the APS trial. It was also a RICO conspiracy case. The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy.
that is also in MacArthur, which is MC capital ARTHUR versus Beach, which is BEECH. Haven, which is HAVEN Baptist, BAPTIST Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit 2 or more predicate acts. There's also Wiley, which is WYLIE versus Denton, DENTON, which is 323 Georgia Appeal, 161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for a conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, SPACE, Inc. versus Dan Tanners, DANTANNA CNN Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mm-hmm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, EUBANKS, State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, HEATH. Once the jury is sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that, I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And I assume this got argued at one point before if the prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order, and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached it, but I didn't give you my brief. So the court's permission, and of course, the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Oh, okay, that brief. Yeah, sure. I'll take it all.
Okay.
And then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's worth.
The state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So, and it's a long order, it's 12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay, thank you, Your Honor.
Thank you.
I'll get you that brief.
All right, appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date.
Okay.
Of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was held on November 20th, 2023.
Okay, thank you.
And it was specifically as to defendant Williams' plea in bar / motion.
Great, thank you, appreciate that. All right, Mr. Harvey, you look like you also were maybe gonna stand up and come up with something we could do. Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57, you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you? Oh, right. Yes, the Harvey rule. Thank you. Okay. If you are all joining in, can you tell me, is this essentially true about every one of the gang counts?
Brothers, sisters, I
they're
debated
missing-
about even
Okay.
interrupting
All right,
for
then.
this right here, but I've decided to go ahead. Shout out to Miss Love. You know, we talk about her emotions and her lack of control at times, and she certainly just gathered herself in a major way. And so shout out to Miss Love. We'll show it to you, and clearly you may have even caught it. The woman was trying to speak. Brother Steele had just brought up something that was totally, you know, taking what she should do, right? Bring up something that if there's a gap in the schedule, nobody knows what to do, and he brings it up. Hey, that's cool. She begins to talk, and the judge is like, yeah, I'm not really trying to hear anything else you got to say, and starts talking over, just interrupts Miss Love, and Miss Love sits down, and you'll see her left hand, symbolizing her woosah moment as she's trying to keep her composure. So shout out to Miss Love for holding it together, and you can see that that's exactly what she did. So we got to give her credit when she does it. All right, so we'll see. I don't think the judge needed to be cutting her off, especially since they don't even have anything on the schedule right now. So to cut her off is pretty
Great,
ridiculous.
thank you, appreciate that.
Okay, hold on, brothers and sisters. Let's get that for you. One moment, please.
Get the motion, I attached it, but I didn't give you my brief. So with the court's permission, and of course the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Oh, okay, that brief. Yeah, sure.
the whole brief.
I'll take it all.
Okay.
And
there's-
then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's
No,
worth.
the state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order, it's
Yep.
a 12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay. Thank you, Your Honor.
Thank you.
I'll get you that brief.
All right, appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date
Okay.
of at least one of the hearings where we addressed
Okay,
Defendant
so
Williams.
here we
general
go, it's
demurrer
coming
claim.
up.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was held on November 20th, 2023.
Now you see, she's going to cut her off.
Thank you.
Whitaker's going to cut off Love.
As to
Love will sit
Defendant
down and
Williams'
watch her
plea
left
in
hand.
bar /
Watch
motion.
Love's left hand.
Great, thank you, appreciate that. All right, Mr. Harvey, you look like you also were maybe gonna stand up and come up with something we could do.
Shout out to Miss Love.
Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you? Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
Okay, brothers and sisters, we have a break in the feed, so we'll be right back.
But you wouldn't want me any less.
All right, brothers and sisters. So we did get a little chopped off at the end there. So what we'll do is we'll play the little clip at the end, right before the recess. The live feed, the court is on recess right now. Clearly, they'll have nothing to do. She doesn't know what to do. Whitaker is stuck, so she's trying to figure something to do. So meanwhile, they are on another recess. So we'll replay that, the end of that little clip, a couple of minutes, and see if they're back. If they're not back by then, we'll might throw a little more music in the mix, or we could talk about some things. What's your pleasure? What's your pleasure, baby? All right. Well, let's run through the last little piece right there.
All right, Mr. Harvey, you look like you also were maybe gonna stand up and come up with something we could do. Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you? Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is, the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I could write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for I mean, I know if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about overnight that is different?
Only for the defendant.
Okay.
And the defendant's counsel. That was the whole basis of Perry versus Leak.
Right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So your You're
Hazy
close.
memory.
Yeah, yep.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case, not from within Georgia, but it literally spoke directly to it. So I was at least looking for that. All right. Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's make sure we get it right. So I'll submit whatever you want to submit on that as well. All right. Thank y'all. We're going to take a recess right now if there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed? Yes, okay.
All right, brothers. This is as promised. So we should be able to jump right to the live feed. Hold on for a moment.
All right, where's Ms. Bumpus? That's who filed the Rule 22. Good afternoon. All right, so you filed a Rule 22 at what, 11:10 or so? That's fine. The night before last. So, and you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus. All right. So I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's live stream. What is that person's name?
Miss Sylvia.
Miss Sylvia?
Yeah, she's sitting in the courtroom.
Okay. All right. So there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just it's a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull. I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time they can say it's copyrighted and take it from me.
Okay.
From my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her? Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who is authorized to have their phone out, who is not. And so what I would like is, until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay. Would that work?
We'll try it out.
Okay, so let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks. All right. Anything else we can do today? Or did I give everybody enough work that y'all can just go home and do your work? And y'all gave me plenty of work to do also. All right. So we are adjourned for the day. How about we see each other at 9 in the morning? Which doesn't mean when we get the jury back. If we get the jury back, I won't go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence, okay? All right.
What is your expectation of the evidence? If you have
we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No? We don't have any of his testimony? I thought we had at least the 11th. When are we getting that? By the end of the day? That was a really good question, Mr. Short. I thought we were going to be doing Mr. Copeland's evidence tomorrow, but maybe not.
Did we ever get an answer, Judge, as to whether or not we have the transcripts from the 10th? I know that Ms. Weaver indicated, excuse my seat, Ms. Weaver indicated that she was working on the one for the 11th. She might have it by the end of today is what I heard earlier. But you asked whether we actually had the 10th, and I didn't hear the answer to that.
The answer to that is no, we do not yet have the 10th. We had portions of the 10th, but they were the other portions of the 10th. So hopefully by tonight, the court reporter will have both the 10th and the 11th. Y'all should have, now this isn't his testimony, this is y'all going through evidence, but y'all should have a rough of the 18th, the 21st, and the 24th already. And then the rest of it will be forthcoming. So I don't know if we can work on Mr. Copeland tomorrow or not. I don't know what can we work on tomorrow? No point getting together as much as y'all are all delightful. No point getting together if we can't get work done. The 18th, the 21st, and the 24th. No, so yes, that. So he testified on the 10th, the 11th, and the 12th, and well, wow, okay. He testified the 10th through the 17th. And then y'all took up matters about the evidence surrounding him the 18th through the 26th. All right. I think tomorrow might be more productively spent with everybody working on the things they need to work on. Tomorrow is Thursday, so let's get back together on Friday at 8:45. Okay. See everybody.
Brothers and sisters, this is out to lunch. I'm just telling you, I'm so unimpressed. Unimpressed. All right. What do you think? What do you? At some point, there should be a question about fairness, though, right? The fairness for the defendants. Is this really fair to them? Wow, so, hey, the elements here, you've got Whitaker, who wants to be Speedy Gonzalez, and just flying through stuff, even though she doesn't really know the depth of what she's talking about. You can tell by even the questions she's asking. So she's just flying through without clearly understanding the depths. What is that? It's pretty disrespectful. Well, I guess she at least caught the reality by giving tomorrow as a work day, because when we said it before she even allowed Brother Steele to take advantage of that moment and bring in something like he brought in, which was great on his part. It was good for him to do that, right? He's advocating for his client, what he's supposed to do. He realizes judge doesn't know what else to do, so he slid something in there. She shouldn't have accepted it. She should have already been sending them home or making them stay right there in the room and work, and she's going to be the after school coordinator or something, and make sure everybody does their homework, study hour or something, a study table, right? But whatever the case is, this is ridiculous. This is absolutely ridiculous. So she comes in with her nonsense. That's what I'm labeling it as now. She's trying to just be a master scheduler, and there's a balance that's needed with all the chaos that's going on, the foolishness that's going on. You can't just be a master scheduler. You also have to be brilliant. You would also have to, balance the scheduling with actually resolving other deeper issues within the situation, right? Helping to facilitate that, the fullness of that, giving more weight to that. Because even if you allow that to happen, this thing may already be over, right? If you really allowed the weight of some of these motions to really be examined, you might find that this thing already should stop. And that's what happened with the recusal, right? Once it finally was, okay, let's take a breath and look at this thing, he was out of there, So what are we going to do? Go through all this, and the appeals court's going to look at this and say, this thing could have been stopped 100 ways from Sunday. It was like, it shouldn't have went as far as it went. Exactly. So then why'd you do it? Why didn't you just look at it? Or, the bond issues. Golly, man, the homeboy is just sitting back there, and you got to look at the chaos. You have to look at this. This is ridiculous. Furthermore, let's say Whitaker, as she, in my opinion, is going to begin some serious self-reflection about her own skill set and how she's running into this mess and can't control it the way she might have thought she could. So as that's becoming more and more apparent, she's giving them tomorrow off. Listen, brothers and sisters. This is the same woman. Who comes in going 1,000 miles an hour. Let's get through it. We don't show up late. Don't come back from break late. Everything's got to be, every second counts. Yeah, I don't have no, you just don't even come tomorrow. Y'all just do, stuck. So what happened to every minute counts? Stuck. She can't control the dysfunction. There's too much that needs to happen. Too much. And the fact that, y'all just do what y'all need to do. Now see, that's a breakdown in her own method. What am I saying? I'm giving her credit for being a master court scheduler type person. Okay. And she's already felt that before when she's caught herself and said, I think I need to be more specific. By Monday have such and such and such and such, right? She's caught herself and said, I think I'm being a little too vague. Let me specify. This is what should happen. And when can you have it? Okay. And they're recording, right? The court, they're putting it down, documenting, okay, by Monday, by Tuesday, whatever the case is. So really, but she's so frustrated, she doesn't know what to do, but she still should have caught herself and said, all right, if I'm going to give them tomorrow off, this is what I'm expecting. These are the benchmarks. This is what I'm expecting be done by Friday. Are we in agreement? Before I send you on your way tonight, are we in agreement? Now, this is something she can do. This is totally in her wheelhouse. So why didn't she do it? Because of what I'm saying to you, brothers and sisters. She's hitting that wall. She thought she could do more than she's able to do. There is no way in the world that she's been watching what she's been watching yesterday and today and heard about. But when she heard about the crap, she just felt like she could fix it. I'm going to come in and straighten all that out. Okay. And now that I don't know what to do, she doesn't even do what she knows to do. So she's losing it. And I'm pointing it out to you, which is another reason why mistrial could start looking a little better, because there are ways she can get out of this mess. Now, again, she might tough it out because the cameras and, and she obviously has pride and all of that. And she has a lot of gusto and she believes she can. But I think that's going to start to get real shaky in her belief that she can. And again, part of the indication is what just happened. She should have taken a breath, given them the task for tomorrow. And she should have even said, hey, now, if y'all can't get these done by Friday morning at 9:00, tell me now. Do you need to take Friday too? And therefore, I know by Monday, I won't call the jury back. And I know on Monday, these are the things that are going to happen. But I'm not playing these things. This is what we have to have happen. And I'm going to hit the ground running Friday or Monday, whatever came out to be, right? But everybody has their clear marching orders all delineated. And we're going forward. Period. No misunderstanding. No, oh, I thought I had time to do this, or oh, I was working on a motion for mistrial, or oh, I was trying to get another bond. No. Are you going to have this done? And will it be done by tomorrow? Will it be done by Friday? Will it be done by Monday? Will it, hey, and if we don't agree to that, then she needs to reorchestrate that. But why even give them the day off tomorrow unless you're going to be specific when you know who you're talking to? Don't leave them any leeway. And she knows how to do that, but she failed to do it. So again, here are the elements. Yeah, she's coming in with this. She's got her insatiable need to just get things done. She's running into a mess. And then the overarching Fonnie Willis aspect of it all. Love and Hilton and Atkins, as we said before, whether they should have had this stuff together, whether it's their duty to have this stuff together, whatever the case is, the stuff ain't together. And they can't just get it together because she's demanding it. They need help. And I'm saying this from the state's perspective. They need help. So bring your team. Bring your team. And y'all support. This is your big RICO case. You want to bring a high profile case. I mean, you got the whole state of Georgia looking a certain kind of way right now. Do you understand what I'm saying, brothers and sisters? I mean, I'm like, hey, man, I'm looking at this saying, wait a minute, you representing my state, let's say, right? Y'all got to do better than this. Get you the Boy Scouts come help you. Get some Girl Scouts to come help you. Something. Get the Little League. They can staple. Do something. Man, but y'all need to up your level. How much more can Love and Hilton do? You see they're stressed out. They're doing the best they can. They're drowning. Where's the support? Well, then you just playing. And I ain't got no sympathy for that. So okay, there are other elements, brothers and sisters, that we've been talking about, and I'll just say, stay tuned, and we'll continue to unravel and dissect. But for now, the foolishness. That's what Rhodes Dog Conversation called this from the beginning. The foolishness. Once you deal with it on that level, you might have a chance when you understand what's really going on. Make sure you hit that like button. Thank you for being here. Let us know what you think. Shout out to Ms. Mod. We'll bark at you later.